Do you want this one?
Something to write on.
This thing will get something in it. Yes, this is no, she says. Oh, yes, it is.
Right.
Because Jesse's already starting. Okay, I got you. That should finish pretty easy. I'm sorry. Yes. Yes. It makes it really easy to know when you're going to have. Okay. What this is? She on red dot?
Yeah. She's not on that. I do one thing.
Okay, motion for sure. No, we haven't looked at it. I don't even have a file. She knows there's all the other cases.
That way, why now I'm gonna handle it all.
Got the admissions. Yeah, there.
Casey would look.
I know.
I know where they are. One, two,
That's what makes me some.
She was appointed to us. Okay, so you can I take the weekend back up here? Is yours?
I'm doing well.
Good, I like it. I'll be there. Oh, thank you. I found your, I thought your, usually got them in emails.
Yeah. Yeah.
We just send me, what are we doing with the send?
You got them wrong, we didn't text you here.
No.
You get to do it. Thanks. You should. You should. Oh, yeah. Yeah.
So, for the year, passing the funds.
All rise. Monroe Circuit Court's now in session. Honorable Judge David Williams presiding. Please bow with me for a moment. Silent prayer.
Thank you very much.
Oh. Commonwealth versus Edward Whitley, 20 CR 0085. Recent investigation. Come around. You want to step around here? Where's the council at? Well, your attorney's not here yet, so we'll have to call you back out here. We'll call you back in a minute. Is they know to be here today? Will you call go ahead and take him back? We all get a hold of them, find out where they're at.
I'll try to do so, Your Honor.
Commonwealth versus Evans. Have you got me a good pen over there? You can have it. Ms. Evans, you say your name Jacinda, is that how you say it? Okay. Commonwealth versus Jacinda Evans, 23 CR 0082. Are you Jacinda Evans?
Yes, sir.
You born in 1983?
Yes, sir.
Last four digits of your social security number, 0437.
Yes, sir.
We're here today for a pretrial conference. What do we have?
Your Honor, we're needing another negotiation day. There's another indictment that's going to be presented before the grand jury.
When is your negotiation day next month, council?
May the 10th at 9 a.m.
May the 10th at 9 a.m. And your next court date will be May the 16th. Both of those are conditions of your bond, okay?
Yes, sir.
Will you think it'll be returned today?
Yes.
Have you provided discovery yet?
Not yet. She won't be arraigned on it. It may be where we need to pass it for 60 days.
Well, here's the thing about it is, if you've got the discovery ready, just go ahead and provide it, just like, if you can, just like it was on the information. That way we won't have to continue it for a while because she's incarcerated.
That's
And so I'd like to get her where we can take a look at her again on May 16th, okay? Okay. Victor Baez. Victor Baez. It's for arraignment. Yeah. There you go. Okay. This is a Department of Public Advocacy case. Who has the case?
Arraignment, are you
It's an arraignment.
arraignment?
Madam Interpreter, you raise your right hand. You solemnly swear or affirm that you are authorized to interpret in the courts of the Commonwealth of Kentucky. You will faithfully do so. Thank you very much. Commonwealth versus Victor Baez, 24 CR 0014. Are you Victor Baez?
Victor Baez?
Yeah.
Yes,
Were you born in 1983?
yes,
Do you have a social security number?
no,
Okay. You're here for the purpose of arraignment. I will read the charges against you. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with possession of open alcoholic beverage container and possession of a controlled substance in the first degree, methamphetamine. You understand those charges?
Yes.
Counselor, do you acknowledge the identity of your client, receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
I'll set a negotiation day for May the 10th at 9 a.m. And the next court appearance, May 16th at 9 a.m. Both of them are conditions of the bond. Now, will you make arrangements for the interpreter for the negotiation day?
Yes, Your Honor, we'll get to working on that immediately.
Okay. Thank you very much. Now, do we have the need for, do you have any other cases here today or?
No, Your Honor, that's the only one I saw on that I have on my list, but I saw a couple of other names, so I wanted to check with you.
Well, let's go down through here and
We
see.
can wait until we continue.
We'll do some profiling on some names here, okay?
True that.
Yeah.
I don't blame those.
I think, Alicia Ballard. Was that a motion to, a diversion? Okay, is there any objection by the Commonwealth on the Alicia Ballard version? Okay. Madam Interpreter, I think that takes care of us here. It's okay. James Dockery, it's active warrant out for James Dockery. Are you here? You need to take Mr. Dockery into custody. They'll process you, Mr. Dockery, and then they'll bring you back out. Okay, go. No. He needs to be processed. You need to be arrested. There's an active warrant out for him.
I got another setback. I'll do the same.
Y'all gonna take him out that way and down or?
Yeah, I want that big one.
Okay, Connie England. Active warrant out. You know, it's NCIC or something. Justin Gillespie. Active warrant.
He's in the background.
Okay. Paul Gold. Good morning. Commonwealth versus Paul Gold, 24 CR 00009. Are you Paul Gold?
Yes,
Were you
sir.
born in 1982? What are the last four digits of your social security number?
7864.
7864?
Yes, sir.
There's been a motion that says that you wish to enter a guilty plea today. Is that correct? You just keep it there. Are you currently under the influence of drugs or alcohol?
No, sir.
You're gonna have to speak up because it's a voice activated
Okay.
microphone.
No, sir.
Okay. Is this plea freely and voluntarily given?
Sir.
Are you the same person that was just identified as being indicted in 24 CR 009? Is your
Yes.
judgment impaired today in any way?
No, sir.
Have you discussed this matter with your counsel and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you and you believe you've been fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir, I do.
You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, the jury, right to be represented by counsel at all stages of proceeding. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses to have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you guilty of charges against you. You understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir, I do.
Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will wait to pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to oppose a harsher sentence, you will have the right to withdraw your plea and proceed to trial. Do you understand that?
Yes, sir, I do.
Y'all step to your left.
Your Honor, this is a diversion plea too.
Okay. Well, let me ask some different questions and wait just a minute.
I need to get it.
Your Honor, please. the Commonwealth-
Mr. Hunley,
Yes, sir.
wait, this is a diversion plea. Let your client get back. I've got some, let him you get on the other side of your client. Let him in front of the microphone. I've got some qualifying questions since it's diversion plea. Have you previously been diverted in the last 5 years?
No, sir.
You had any felonies in the last 10 years?
No, sir.
Are you currently on probation or parole?
No, sir.
You understand that if you complete the diversion program, as charged will be dismissed, you get your record expunged. You understand that?
Yes, sir, I do.
But you also understand if you don't complete the diversion program, you'll be brought back before the court and it can be revoked and we'd schedule a pre-sentence investigation report and you'd be a convicted felon. And any future convictions could be enhanced because of that. Do you understand that?
Yes, sir, I do.
You'll step back to your left here. Mr. Hunley, will you come around and say what the Commonwealth's recommendation is?
Yes, Your Honor. Upon a plea of guilty to assault third, 2 counts, the defendant shall receive a sentence of 5 years on each count to run consecutively, concurrently for a total of 5 years, pretrial diverted for 5 years, supervised. The defendant shall enter in complete anger management counseling scheduled through probation and parole, and the defendant shall enter in complete alcohol counseling scheduled through probation and parole. The defendant shall receive credit for time served, shall be released from home incarceration upon entry of this plea. The defendant shall continue his employment with Walton.
You want to come around here? Is that your understanding of the Commonwealth's recommendation? Is that your
Yes.
understanding, sir?
Yes, yes.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Pardon?
Are you pleading guilty because you did commit the acts in the indictment as amended?
Yes, sir.
You plead guilty of your own free will because you are guilty and for no other reason.
Yes, sir.
Knowing your constitutional rights is still your desire to waive them and allow the court to fix the punishment.
Yes, sir.
Is that your signature on the document?
Yes, sir, it is.
I'll accept the agreement and sign the diversion order. You'll still need to meet with the probation and parole officer. Who's here. He's standing right there in the green shirt. Even though you're not, you'll be under his supervision on this diversion, okay?
Okay.
Okay, thank you very much. Now, the court costs involved in this thing, what are the court costs?
215.
When can you pay the 250?
I could have it within a month.
Well, I tell you what, I'm gonna let you do. I'm gonna let you pay it $50 a month. The first payment be done 30 days from today.
Okay, can
And
I?
30 days after that, you can pay it all in front if you want to, but that'll give you some time, okay?
Thank you.
Thank y'all very much.
Thank you, Judge.
Yeah. Let's go back to Edward Whitley.
Your Honor, the Commonwealth is getting us copies of the victim impact statements. We haven't been able to review those. If we could have a few minutes to look them over before we do the sentencing.
Okay, we'll go back and tell him to keep him back there then. Matthew Hagen. Matthew Hagen. Commonwealth of Kentucky versus Matthew Hagen, 23 CR 0073. Are you Matthew Hagen? Let him behind the microphone. You get over on this side of him over here. Okay, thank you.
Yes, sir, I am.
Were you born in 1987, Mr. Hagen?
Yes, sir, I
And the last 4 digits, social security number 6854.
Yes, sir, it is.
Okay, you're here for a pretrial conference today. What do you have? What does the Commonwealth have?
Your Honor, we either need to make some arrangement on another negotiation date or set a trial date, one or the other.
Call date, Judge.
What is the charge?
Burglary.
Let your client back up here, okay? You need to stay up here in this area here. Okay, let's get a trial date. You think you can be tried in one day?
I think so.
You have witnesses you need time to get, Mr. Hunley?
No, I don't think we have any left here today. I don't think there's an issue on witnesses.
The Bayes trial in Cumberland County is gonna be May 14th and 15th.
I'm thinking that's correct.
Okay. So that would lead, are you gonna be, who's gonna be prosecuting that case?
I will, Your Honor.
And so you'll be doing this one here, so you couldn't do it like the day before then?
I prefer not to.
Yeah.
Just say if he's had a chance to report.
Eighteenth, we had the Simpson case here on June the 18th.
Actually, Judge, Mr. Simpson passed away, so that's been dismissed by the Commonwealth.
Okay. June the 18th. Okay, trial June the 18th. Jonathan Hale. Jonathan Hale. Thank you.
If I may be excused,
Sure,
we
thank
just
you.
found out that nobody else needs me.
Thank you very much.
Thank you, sir.
Thank you. Have a safe journey.
Thank you.
Jonathan Hill, there's an active warrant out. Y'all need to look at NCIC. Gary Hall. Commonwealth versus Gary Hall.
Morning, Judge.
Morning, Mr. Bell.
I believe that's on my, here initially on my motion and.
Well, let the defendant get up here first.
All right.
You're Gary Hall,
Yes, Your Honor.
born in 1978,
Yes, Your Honor.
last four digits 6975. Okay, and if y'all move to your left here, Mr. Hunley.
Your Honor, this is scheduled for trial next week. And I have filed a motion on the 10th of this month. Mr. Hall is charged in the indictment with a series of events that occurred on the same
You're
day.
severing the gun charge.
And I have asked that the gun charge be severed and I have elected to try it first.
So you're gonna try the gun charge next week?
Yes.
Okay, that's fine.
We object.
Well, the gun, come over here. The gun charge has to be severed. You cannot try the gun charge at the same time with the others.
I understand that, Your
Okay.
Honor. But our position is that due to our defense of this case, and I believe the Commonwealth realizes that, to sever the gun charge and try it first is going to prevent us from having defense against the assault first charges, because I believe they're so closely connected. It's going to be.
I'm lost here. Okay, the fact that the person is justified in using deadly force in self-defense is not affected by whether or not the gun was illegal or not. You know, I will not allow that to be introduced at a trial on those other issues.
We're not talking about self-defense, Your Honor. We're talking about whether he had the gun at all or whether he shot the gun at all. That's the question here. It's not a self-defense.
Oh, well, I would assume that it was. I guess I had it wrong or something. You say he wasn't there and he didn't do it.
Well, I'm just saying he didn't do it. I'm not saying he wasn't there, but we're saying he didn't do it.
Okay, well, what difference does it make which one of the charges you try first? You kind of lost me.
Well, in defense of the assault in the first,
If
it would
he
seem to me
didn't
that's
do
gonna
it-
give them two bites at that apple instead of one.
Well, you can't try both of them. You realize they have to be severed. Because it
that.
would be highly prejudicial to introduce in front of the jury that he is a convicted felon
Yes, sir.
and that. So, I mean, if they're severed, the Commonwealth has an opportunity to choose which one they proceed with, it appears to me.
Well, you're the one that matters, Judge, so if you say several.
You
we'll
matter
sever.
to me too, Mr. Bill. I want you to know that you matter to me, you know.
But, we'll be here Tuesday, ready to go with,
Okay, well, the gun charge will be there and this, and on the other charge, you can't change your mind. It's the gun charge or nothing next week, and then we'll have to reschedule the other one at some juncture, okay? Okay,
Judge, there was also a 404B motion filed. I got some of the information late Tuesday evening. I'm assuming due to the trial of the gun charge, not the other charges, that motion is in abeyance until we get to the other side of it.
Your Honor, the 404B, I filed the 404B as a cautionary matter, that I didn't want to hit that issue on the day of the trial.
what was the issue?
Motion on the 404B, there will be evidence in it that will show exactly where Mr. Hall acquired the gun that night and exactly what he did with it that night. And otherwise, I don't have that proof. I can go into detail if you wish on it.
I'd like to sidebar on that, Judge, because if they've got that information, they've not provided it to us.
That information has been certainly provided to the defendant and to his attorneys in the form of a recorded telephone conversation. And it was the basis for the assault first charge to begin with. Certainly I wouldn't
Well,
be.
now you know where to look for that anyway.
Well, I know what you're talking about, but I don't think that recorded statement says what he says it said, but I mean, so be it, but.
Well, that's the only information that he's asking to be identified as 404B, so he can't bring any other things up.
Well, he sent us a whole list of things Tuesday evening that he wanted to bring up, and if we're gonna try just the possession of the gun charge, that's all I wanna try. I don't wanna allow him right now. I respect Mr. Honey, I think a lot of him, but I've had trials with him before, and.
I have too.
And, you know, I know to be cautious to say the least as far as what he's wanting to bring in.
You're not saying he put his thumb on the scale, are you?
Well, I mean, I'm saying he would, but I'm not saying I would. So, you know, I'm not saying anything about him I wouldn't say about myself, but I'm just saying that I'm trying to, if we're going to try the gun charge, that's fine, but that is a very singular, easy charge.
Well, let's just put it like this. You can give notice to the 404B. That doesn't mean that it'll be admissible when we get to the trial. You understand what I'm saying, Mr. Henley? If you're just going to.
Well, yeah, I do
Because I
understand
don't-
what you're saying, Judge.
I don't know what the 404B, when you bring something up, you need to file some sort of a motion in limine or something. I can't rule on what he can get in or get out if I don't have a motion in limine.
The problem with that is, Judge, I didn't give information until late Tuesday evening.
Now, come on, Johnny.
I mean, I've got it.
You've had that from the day this thing was filed, and you know you have.
Well, let me tell you what you can do. Wait just a second. Tell you what you can do. You can file a motion in limine if you have something you feel very strongly about. And what day is the trial scheduled?
It's Tuesday, I think.
Tuesday. Well, I've got, till noon tomorrow. Take a look at it, and by noon tomorrow, I'll take a look at anything. And if I need to, I'll get y'all back on the phone. At least I'll know what we're looking at when we come here on Tuesday. Is that fair enough to you?
Yes, sir.
Yeah, okay. Thank you very much.
Be free to go.
Yes, absolutely. Brian Hunter. Commonwealth versus Brian Hunter, 24 CI 004. Are you Brian Hunter?
Yes, sir.
Were you born in 1992?
Yes, sir.
Last four digits of your social security number are what?
3209.
Okay. You're here today for a pretrial conference, Mr. Hunter, in 24 CR 004. What does the Commonwealth have to say?
We're ready for a trial date or a negotiation day to be set for Mr. Brian.
And Judge, the issue, and I'll kind of take the lead here. We've not received all discovery from Mr. Hunter.
What's the charge?
It's a possession charge, Judge, and we don't have labs back yet.
You gonna turn this case over to
I will
some?
be, Judge.
Y'all wanna come and make your entry here? Mr. Pennington's relieved. We'll find out if they have the labs.
We do not have lab stack, so we'll need another negotiation day.
Okay, let's bring this case back here on May the 16th. If by some reason you were to get the labs back before the 10th, we'd schedule him for a negotiation day on the 10th. If the labs are not back, it'd be the 16th. So, sir, you need to keep in contact with your lawyer here to understand whether or not the labs are back. You follow what I'm saying?
Yes, sir.
Okay, thank you very much.
Thank you.
Shannon Keith. Shannon Keith. Shannon Keith is down for probation revocation. What's it?
Your Honor, his ride, spoke with him this morning and said he wouldn't be here today because he was passed out drunk. Said he couldn't, he said he went to his house to pick him
The
up.
driver was, or Mr.?
His driver was there to get Mr. Keith and he was passed.
Well, we'll know where Mr. Keith is for the next court day. Issue a bench warrant for him. And we'll provide him transportation to court. Robert McLendon. Commonwealth versus Robert McLendon, 23 CR 0072. You are Robert McLendon, born in 1972. Last four digits of his social security number 9729, is that correct? This says a motion to secure attendance. What is this?
Trial date set
Yes.
in May.
And
we
Judge-
sent it back.
Judge, just as a point of order, it shows DPA listed, Mr. Bell is representing you, correct?
Yes.
So,
Is Mr. Bell back there somewhere? Could you retrieve him?
Oh, we did.
421. Mr. Bell, Mr. McLennan has already been identified. There are two motions to secure attendance of out-of-state witnesses. Is that correct?
I don't have any objection to that, Judge.
Yeah, I'll enter the orders in.
That's fine.
What day is this trial scheduled for? I've got it here somewhere.
May, isn't it?
May 21st.
Yeah, and 22nd.
Yeah, May 21st and 22nd. See you then. Okay.
Thank you, Judge.
Thank you. William Miller. And that's to commission. I want to talk to him. William Miller.
Wow. Okay.
We can check on his location.
So,
This is probation revocation. Is he incarcerated?
Not to my knowledge, Your Honor.
Could you check on that?
I will.
We'll check and see.
Judge, I think this is something out of Tennessee.
Yeah, I provided the revocation motion to his officer in Tennessee, and he told me that he actually provided that to him, and he knew to be here today.
Okay. Then we'll issue a bench warrant with no bond. Jacob Newberry. Jacob Newberry. Commonwealth versus Jacob Newberry, 22 CR 00629. Are you Jacob Newberry?
Yes, Your Honor.
Were you born in 1980?
Yes, Your Honor.
Last four digits, social security number 2356.
Yes, sir.
Now, is this a felony plea or diversion?
Judges and neither. I guess we're gonna need a trial date.
I thought it had on here motion to enter a guilty plea.
That was correct, Judge.
As they say, it's fallen through. Is that correct?
Yes, Your Honor.
Okay, what kind of case is this?
Possession.
Okay.
And Judge, if I may, while you're looking at your calendar, just as a point of order, if this trial is set post June 18th, it would be a case that the Department of Public Advocacy would inherit. If it's before June 18th, I would grandfather to that case.
Okay.
I know when we were here at last real day, and I can check my availability again, I know with Mr. Simpson, we had set his trial for June 18th, but I don't think my availability is any better, but I don't care to check, and obviously with the Commonwealth and the court.
But we just set one, we just set the Hagen case for the 18th. Seconds ago. When you said Simpson deceased,
Correct.
I just set one on the 18th.
I was gonna say, Judge, if you're looking at any date past that, that would be the Department of Public Advocacy.
Yeah, I understand that.
Oh, well,
I plan on it.
well, so Mr. Bell, you might be picking up a new client too.
I'm gonna talk to you. I'm gonna try to get you to overtake this case.
Well, why don't you step out and talk to him and then come back in?
I mean, I'll be honest with you, I'm gonna have, unless you got money to pay me.
That's what he's gonna talk to you about, okay?
I mean, I ain't gonna.
I mean, I can't make him write a check. You get back there and see if he got any money. If he doesn't, we'll proceed, okay? You want me, I can count it out on the table for you or whatever you want me to here. I don't know. Okay, Commonwealth versus Robels.
Me too.
Fatima, is that correct?
Yes.
Commonwealth versus Fatima Robels, 24 CI 00015. Are you Fatima Robels?
Yes, sir.
Were you born in 1996?
Yes.
Last four digits, social security number 6935.
Yes.
Represented by Mr. Gary here on a pretrial conference. What do we have?
Judge, there's a co-defendant in this case, and I don't think a trial date's been set. We don't have an offer or anything at this point.
We just have it set for, just to pass it to another negotiation day.
Okay.
That's
Well, let's do a
what this-
negotiation day on May the 10th,
Yes.
and the next court appearance is on May the 16th. You're under the same conditions of your bond. Okay?
Thank you.
Thank you.
Angela Russell. Commonwealth versus Angela Russell, 22 CR 00102. Are you Angela Russell?
Yes.
You born in 1973?
Yes.
Last four digits, social security number 3917.
Correct.
Okay, you're here today on a pretrial diversion revocation.
We had filed this motion, Your Honor, several months ago because there hadn't been any payments towards restitution.
Yes.
After we filed the motion, she made a substantial payment of $1,000, and since then she has made 2 more payments. So the Commonwealth would like to continue this out for
Well,
60 days.
you'll withdraw your motion for revocation of pretrial diversion with reserve the right to refile it.
Yes, Your Honor.
Okay,
All right, thank you, Judge.
Thank you.
Chad Shirley. Chad Shirley. Morning, Ms. Shirley. Johnny Bell represents you.
Yes, sir.
Did you get Mr. Bell?
Case there's a number.
Mr. Bell, Mr. Chad Shirley has identified himself here. He's here for the purpose of arraignment.
Yes, sir.
He was born in 1990, last four digits, social security number 4625.
Yes, sir.
You have a right to remain silent. You are represented by counsel here. The grand jury of Monroe County has returned an indictment charging you with being engaged in an organized crime, criminal syndicate, and trafficking in controlled substance, first degree, first offense, hydrocodone. You understand those charges? I'm not saying what you did or not. You just understand what the charges are. Okay. Mr. Bell, you acknowledge the identity of Mr. Shirley, received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir, Judge.
Yeah, Mr. Shirley, I am signing a reciprocal discovery order which the Commonwealth has a responsibility to provide to your attorney for your review, certain things that will help you prepare your defense. You're under continuing obligation to provide those things. We need to schedule this thing for a negotiation date. Is that correct? On May the 10th, and your next court appearance will be on May the 16th, and you'll continue under the same bond, okay?
Yes, sir.
Thank you, Judge.
Thank you. Commonwealth versus Alex Tully. The active warrants out. You want to do NCIC?
Yes.
Benjamin Tully.
Your Honor, please, we request that be passed for 60 days. Commonwealth has interested in.
June the 20th. Mr. Tully, your case at the request of Commonwealth would be continued to June the 20th at 9 a.m. Okay? Thank you. Maria Zioli. Maria Zioli. Are you Maria Zioli?
No, I represent her, Judge.
What is she today?
Judge, I've tried calling her. I'm not sure. She's been diligent about being here every time.
Okay.
There was a negotiation day that got bumped because I was out of town.
Okay, well, you can see her in the Barron County Jail. And if she's got a good excuse, you talk to Commonwealth attorney and I'll consider that, okay? Yeah. Issue a bench warrant. Okay, now let's go back up to Mr. Edward Whitley. Are we ready now? The precinct's investigation. Mr. Whitley, do we finally have everyone ready for your sentencing? Are you Edward Whitley?
Yes, sir.
You were born in 1991?
Yes, sir.
Last four digits of your social security number are 9864.
Yes, sir.
We're here on 20 CR 0085 for your sentencing. You're represented by counsel. Have you had an opportunity to review the precinct's investigation report
Yes,
done by probation and parole?
Yes.
And there were some witness impact statements that were provided by counsel a few minutes ago. Have you gone over them with your client?
We've not reviewed them with Mr. Whitledge. We've reviewed them, Your Honor, and we've indicated to the Commonwealth which of those we object to under the statute as being submitted by people who don't qualify as victims. I don't know if the Commonwealth's in agreement.
We're already, we'll limit those to the ones that qualify.
Okay.
Okay,
Sure.
yeah.
In preparation of this argument, Hoskins versus Miracle is a 2004 Kentucky Supreme Court case states that nothing prevents the court from considering testimony of those impacted by the crimes. There is merely no statutory authorization for others to do so. Besides those identified as victims in the statute, furthermore, the court is permitted to consider as many victim impact statements as they desire.
Your Honor, I would just say if that's from 2004, that's prior to the passage of Marcy's Law, which limited the definition of victim further.
And there's a unreported case that states that KRS 421-500, the new law pertaining to victim impact statements, does not preclude consideration by the trial court of statements from friends or family.
Okay, who's going to make a statement here today?
We've got the parent statement is my understanding.
We have two victims, John.
We've got two statements that are going to be read today.
And we don't object to any of the statements they're reading out loud. It was the written statements that don't qualify to be submitted to the court or the parole
There were
board.
some that were submitted by cousins and aunts and a stepfather that they're objecting to.
How does Marcy's Law limit that?
Well, Judge 421-500 defines victim for the purpose of the victim impact statement statute, which is 421-520. And it limits the victims that are
When was
able-
that statute passed?
Marcy's Law, 20,
I thought,
20?
wasn't there a constitutional amendment?
yes,
Well,
2020.
the constitutional amendment would trump any statutory,
This is the statutory, this is how Marcy's Law has been implemented in the statute is 421-500.
well, I know, but you don't really have to, does Marcy's Law constitutional amendment says statute has to be enacted to implement it?
Marcy's Law states that
The
victims,
constitutional amendment's what I'm talking about.
that is Marcy's Law is my understanding.
Well, I'm saying, does the constitutional amendment limit the testimony I can receive? I know the General Assembly has passed a statute in which they're trying to set standards and implement those sort of things. But what if I found that the Constitution trumps the statute and I can hear anything I want to as far as victim statements?
Judge, I don't think the constitutional amendment defines victim, and I would object to that finding, but obviously the court is the one that makes that decision.
Well, did you were there written motions and objections today? Because you didn't get it till today.
That's right, we requested
Okay.
them ahead of time and
I
were not
understand.
provided, or I would have filed something written.
Well, I'm gonna let, these are cousins and what's the relationship?
So the ones that they're objecting to are cousins and aunts and a stepfather.
Show me the statute real quickly.
I have it on my phone, Judge. Do you have a green book? I can.
Yes, it's an old one. I used to 22, so
And we just get a green book every 10 years.
we don't know when that was printed either. So
Same though. Okay, but thank you.
What is it? What?
421.
421-500 is what I'm referring to.
This would be close to whenever it was enacted.
Well,
500. See. There.
damn it.
There it is.
There you go.
There it is. Let's see.
D.
Mhm.
Let's start on the fact that the victims are dead. Deceased, and this would be the ones that would.
Say one thing, the young lady never quit, did she? Relentless.
No.
You know, this brings up a kind of a topic to me that I hadn't really thought about. When I thought about Marcy's Law and I thought about who were victims, I didn't just think of the deceased as being the victim. I think that the families and the relatives, and they're all victims.
I may be mistaken, but I think the issue today is not what are going to be read here today. Is that correct?
I just don't want it in the record.
Well, our proposal is that a sister will be reading for the entire Cleary family.
And the other is,
She's making one presentation. Sister-in-law will be reading for the entire Copus family. There are other members of each of these families that want to file victims' impact statements, which I assume would become a part of the record, which would be forwarded on to the Department of Corrections. And I think maybe that's their issue.
that is their issue. And that's what I'm saying. In my past consideration of who the victim was, we have a deceased victim here.
Correct.
So they're saying that the deceased is the only victim, and that these other folks are, it says if the victim is deceased and the relationship is not, and the relation is not the defendant, the following relations shall be designated as victims for the purpose of presenting victim impact testimony. That's subsection 3 of paragraph 1 of 421-500.
My question to the court would be, would the simple filing of a statement be
What it
testimony,
says.
under
It
this?
says that. Look at C and read it. The victim is deceased and the relation is not the defendant. The following relations shall be designated as victims for the purpose of presenting victim impact testimony under KRS 532.052A2. Testimony can come by the way of being here or being presented. That's what they're saying. And I think that anything that's presented for the record is testimony, because it shall be considered.
Well, that answers my question.
Yeah, I mean,
Not the way I wanted it, but it doesn't.
well, I'm putting that forth as what it appears to me, is if anything that shall be considered at any later proceedings have to be testimony if it's attached and presented, whether it's given in open court or not. So the other thing is I don't know whether an in-law is included in that or not. It says a spouse, an adult child, a parent, a sibling, or a grandparent.
Your Honor, if you'll read section B of that, I believe it authorizes the court to fashion a reasonable procedure that does not unduly delay the proceeding.
Give me one.
You have to look at C. If the victim is deceased.
Is it related to the brother?
I was just seeing on that C where it says under that statute specifically refers to testimony under the sentencing penalty phase.
The definition of victim provided in 421-500 is the definition of victim for 421-520, which covers written impact statements.
Saying that that specific section that C refers to. Brings the Commonwealth they put on there.
Yeah, you're talking about 532.0552A7 talks about at trial. What do you have to say about that?
Could I, well, actually, let me pull it up on my phone.
Here, come up here. I'll share my piece of paper with you.
So what I'm referring to here,
I'm wanting you to look at C. It's a different question I have. So the C doesn't apply to this, so a sister-in-law.
1A.
I just want to answer about C. C does, so you have no objection to a sister-in-law making a statement, do you?
I don't think there is a sister-in-law making a statement.
There's a sister-in-law that's going to read for the Copus family, the mother and the father and the brother's statement out loud today.
I don't
And it's
object
her
to her
statement too.
reading
It's,
a victim
That's all
statement.
I'm asking.
But yeah, 1A.
We got two
is what I'm
statements that are
referring
gonna be
to.
read, okay?
Yes.
Okay, and then, what I am almost, have a tendency to do, get Mr. Hunley back in here too, so both of them, because I don't want him to come and complain after I do. Mr. Hunley, I was just telling him what I'm almost inclined to do is let each one of the families read their statements. Then all these other statements which you object to, I'm going to admit, but I'm going to seal them. Okay? And then if you want, if the Attorney General's office wants to appeal my sealing of those, then they can and open them. Or if they don't, I don't know any other way to do it, really. Or I can, I haven't read them. So I'm inclined to just go ahead and admit them. I'm gonna go ahead and admit them and you can appeal that, okay? That way we'll have some, yeah, I'm not gonna seal them. I'm just gonna admit them. And, you can appeal the admission. They'll be separated, okay? Okay, if you'll take a seat right over there. Is there any reason, we're gonna have impact statements read, and then I'll ask you if there's any reason this gentleman should not be sentenced then.
Okay. We had another issue with the PSI that we need to bring to the attention of the court, but we can do that.
No, go ahead and do it now.
Judge, this issue pertains to the jail credit assigned in the PSI. Mr. Whitledge was not credited for the time he spent in custody in California while being held on these Kentucky charges.
Where's probation parole officer? Wait, look at him.
You need back just a second.
Okay, we have a jail credit issue that I just wanted you to hear, okay?
Well, we will correct that.
Well, I don't know whether it needs to be corrected or not.
Okay.
We hadn't heard it. Go ahead.
Judge, Mr. Whitledge was assigned credit in the PSI
Wait
from
a second. Y'all listen to what they're saying here. Okay, thank you.
an arrest date of May 25th, 2022. And Mr. Whitledge was technically held on this Kentucky warrant since October 9th of 2020. So we are asking the court to assign him the appropriate credit beginning from October 9th, 2020 up to this point. According to KRS 53.
Do y'all have any objection to that?
We do, Your Honor.
Okay.
I spoke to Mr. Stockton because I just was informed of this issue just about 20 minutes ago. Mr. Stockton said he would object to any jail credit from California because he did not waive extradition that was out there. And because of all the trouble that we had getting him back here, he objects to any credit there.
And Judge, in terms of the extradition waiver issue,
Was he in on any California charges?
Yes, he
Wait
was.
just a second.
Judge, when
Was he
this,
in on any California charges?
yes, and
Was
those,
he able to make bond on the California charges?
no.
Why?
Judge, he
What were
was-
the charges in California?
It was possession of a firearm by a convicted felon, and that charge stemmed from the search incident to arrest.
I'm not, yeah, it might have stemmed from that, but I'm not gonna give him jail credit, so you can appeal that.
And-
He was there on a California charge on a possession of a firearm by a convicted felon.
And Judge, he was arrested on the California charge the same day he was arrested on the Kentucky warrant. He was simultaneously held
I
on the
understand,
California.
and I'm denying him jail credit for that, okay? And that will be clear, so you can appeal that, so you can preserve his right and appeal that. But right now, you bring it up today, the Commonwealth has no notice of it. And the bottom line of it is he was in, and if you can prove that he could have made bond or did made bond and they were holding him on this, but right now, the only information I have is he was being held in California on a gun charge that happened because he was arrested on this charge. What if he'd been arrested on murder or any other things based upon this charge? I'm not going to give him jail credit on that. And you have anything else?
I would just clarify for the record, Judge, we notified probation and parole of the issue as soon as we received the PSI, and we also notified Mr. Stockton ahead of today.
Mhm.
So I just want to clarify that the Commonwealth
fine.
did have plenty of notice that we had an issue.
Okay,
with jail
well,
credit.
the notice is not what bothers me that much now then. I appreciate you telling me that. Okay. And if you'll have a seat over there, sir. And who would the Commonwealth like to call for a victim impact statement?
He's seen it.
Good morning. Identify yourself, please.
Taxi to court, I'm Trevor Clary's sister.
Okay, now you're gonna have to use your outside voice.
Sorry.
And if you need to stop anytime during it, you can stop. Okay, you may proceed.
Okay, thank you. The death of my brother Trevor has devastated our whole family. We miss Trevor. So much. The actions of Edward Whitledge has greatly affected our lives. Our family lost our smiles that day. Our family no longer gets together at family events. We will never forget nor understand or get over how Trevor was brutally murdered. Multiple family members suffer from PTSD, anxiety, and depression since the murder. The nightmares have never stopped. This is the most emotional, tragic, vivid thing we have ever had to go through. We will never get to see Trevor get married, have children, get his dream job of being a diesel mechanic, all because he was taken way too soon from us. Trevor was a good guy, loved attending church. He loved football and loved all of his friends and family. Our family deserves justice. Trevor and Austin deserve justice. Edward Whitledge deserves life in prison. That's all.
Would you call your next witness, Commonwealth?
Taylor Copus.
Good morning.
Good morning.
I am Taylor Copus. I am Austin's sister-in-law, but he was the closest thing to a brother that I will ever have. The first thing I'm going to read is the perspective from his mother. My world has been changed forever. One of my children is missing. My heart is heavier than I could ever imagine. It has been 42 months and 28 days since Austin was taken from us as a result of an admitted unexcusable act of disregard for human life by a cruel, heartless murderer. The pain is excruciating. The fact that he is gone is devastating to my family and me, and also to anyone who has had the pleasure of knowing Austin in his 19 years. Most days I feel emotionally saddened by the fact I have to face the world without my son. I pray every morning that this whole thing is a dream from which I will be awakened. Our lives are changed and we have to figure out how to survive. Austin would want us to be strong. It is easier said than done. The pain I feel is just as strong as it was the day his life was taken. Austin will be forever in our hearts. The next statement I'm going to read is a perspective from his siblings. Austin was a son, grandson, brother, cousin, and friend to many. His soul was pure and his heart was full of so much love. While we can look back on all the memories we have of him, we will never get to see what his future held. He had hopes and dreams that have been taken from him forever. Joey and Glenda, Austin's parents, have been robbed of their most precious gift from God. I cannot even begin to describe the pain that they have gone through, and unfortunately, there is nothing that will heal their hearts. Knowing this man is away from society, unable to hurt anyone else, at least gives comfort to know the rest of their loved ones are safe. My children realize that their uncle is in heaven, but I know one day I will have to reveal the truth of this terrible crime to them. We carry the burden of this daily as we want to protect their innocence for as long as possible. And as for you, Edward, I pray for your own family. I pray for your dad because you've put him through so much. I will leave judgment up to God on your soul. And I pray you remain incarcerated for the rest of your life. Thank you.
Commonwealth have anything else?
No, Your Honor.
Mr. Whitley, as you come around. Mr. Whitley, upon a plea of guilty to murder, count one of the indictment, you shall receive life imprisonment without the possibility of parole until you have served 25 years. Upon the plea of guilty to murder in the count 2 in the indictment, you shall receive a sentence of life in prison without the possibility of parole until you have served 25 years. The court costs in this case shall be waived considering the length of your sentence and your indigency. Okay, you shall transport the prisoner to the Kentucky State Penitentiary.
And Judge, just one more issue briefly. We had filed a motion to have Mr. Whitledge transferred to the Department of Corrections no later than 45 days from final sentencing. So we would just ask the court to sign that order.
I'm not going to sign that order because I don't have any control over the Department of Corrections. It's a separate branch of government.
And Judge, it is a statutory requirement. And should the Department of Corrections,
if they don't do it, you can bring it back in front of me. If it's already a statutory requirement, why am I signing an order to let them? That's what I'm saying, that if they don't do it, you can bring it to my attention, okay?
Judge, and if that were not to happen, the court has authority to hold the Department of Corrections in contempt. That is a remedy provided by the case law. So we just ask the court to sign it at this time.
There's no reason for me
be
to sign it. Bring it back if they are in contempt. You can file a motion to hold them in contempt if I have no reason to believe that they won't transport it. Okay? Thank you very much. Now, Mr. Bell, do you have a new client?
No.
Okay. So now do we have Mr. Dockery? Has he been processed yet?
They're processing.
And we have Mr. Gillespie, he's being processed. Okay, now was there someone else? Who was it you were talking about? Mr. Bell, who was it that tried to talk to you?
Newberry.
Yeah, I must have.
That was the inquiry about the new client.
Yeah, I know, but I must have marked him off here. There he is. No, Jacob Newberry. Jacob Newberry, okay. And he's yours if it's before the 18th, right? Is that correct?
Correct, Judge.
What about Friday, April 26th?
We need the lab examiner and they're booked all the way through April.
You have dates for them in May?
The. In May, yeah, let's look.
May 17th, are they available on May 17th?
Yes, the 17th.
Miss,
We can have the lab with me.
not sure what it is, but I have Jesse off that day.
Oh, okay.
Well, he doesn't have to be here.
I just didn't know who was trying.
And Judge, I have trial 15th and 16th.
How about the 20th? See, the problem we have is we have trials in Monroe County the next week. The 14th and 15th, we have Cumberland County trials. We could do May the 13th. You have lab people available Monday the 13th.
We don't have the test, Your Honor. Do we?
I'm Newberry.
Oh, I'm sorry. I thought you said we didn't have the result.
That was on the other case.
Okay, sorry.
Never mind.
The 13th is first.
May the 13th.
1 second, Judge. Judge, I'm not available May 13th.
What have you got going on?
I'm actually in Clay District. Yeah.
May 13th.
Judge, I'm in Clay District that day, and I can't get that moved. And Judge.
What's the last day you're available here?
June 18th.
Okay.
And I'm not available the 10th through.
Wait a second. What about June the 7th?
That's what I'm available that day, but Mr. Stockton wanted to flag that for negotiations, so I don't.
I'll be available.
Well, he can flag some other day for negotiations.
Yeah, we're waiting on the computer to make sure the lab examiner said that. Slow.
And I know there was talk of, will there be any supplemental reports? I know that was discussed at suppression. I just want to make sure there's no outstanding issues.
I don't know of any.
About 5 minutes ago, he was in it complete.
Yeah.
Well,
Computer's being slow on showing us.
Do what?
I said our computer's being slow to tell us if the lab examiner is available that June 7th.
Well, you just have a seat over there, and I'm gonna go see if we can get FCI Petersburg on the line, because it's a federal correctional institution and we've had trouble getting there. Federal Correctional Institute Petersburg, are you on the line? FCI Petersburg?
Yeah, can you hear me?
Yes, I can. I can't see.
Okay. All right.
Okay, thank you. Are you Joshua Vincent?
Yes, sir. Yes, sir.
Okay, this is Commonwealth of Kentucky versus Joshua Vincent, 22 CR 0001 and 21 CR 00132. Will the Commonwealth come around, and what do you have in this case?
Pull the file, Your Honor.
This is the case, I believe, Mr. Bell, where they were wanting to move Mr. Vincent to a different facility and couldn't do it while this charge was pending here. Is that correct?
That's correct, Judge.
Is it?
That Mr. Stockton was wanting to put a hold on Mr. Vincent, do a warrant for
You need
him.
to speak up.
To put a warrant on, to issue a warrant for Mr. Vincent so that there would be a hold on him. I think he was wanting to go to a halfway house, maybe?
Yeah. Can you hear what's going on, Mr. Vincent?
Yes, sir. Am I allowed to speak right now?
Well, not yet. Wait just a
Okay.
second.
All right.
Judge, I think where the confusion with Mr. Stockton's leave process is when they talk about halfway house, a halfway house for the federal will be incarcerated at the Warren County facility at the jail. He will have the opportunity to go out and get medical treatment and things like that. But even if he's released, he's still going to have 5 years supervision, federal supervision. If he doesn't show up, then.
But what's the deal that you're wanting the state to do?
He's got.
Here, what do you want us to do here in Monroe, sir?
We don't want a hold put on Mr. Vincent because he's in stage 3.
Cirrhosis.
He needs a transplant. They've got a possible donor. They need to do the testings. He only has a short period to live unless something is done. Mr. Stockton had wanted me to get medical records and things of that nature, but because we're dealing with the federal government, I cannot get those records on behalf of Mr. Vincent. And the only thing I'm asking, Your Honor, is not to put a hold on him so they can transfer him to the Warren County Jail. I'll be candid with the court. The individual that makes the placement, I believe, is his aunt or cousin or somebody, and they've already advised us that they're going to accept him into the Warren County Jail. He has to be there every night. He only gets released during the daytime to go for his medical treatment. You only get out down there for medical treatment or a job. He can't work because of his situation, his circumstances. The only thing he'll be let out for is to get his medical treatment. And it's my hope and desire, Your Honor, that he would not have a holder put on him so that he can at least be able to pursue an opportunity to live if it's
Okay, here's what I'm asking you. Hold on him, keep him from being transported to Boulder.
Yes, sir.
Okay, see, that's the issue.
And I think Mr. Stockton's position is without any medical record, you don't have anything to rely on, the fact that that's why he needs to go there. So,
I sent a copy to, my mom has a copy of them right now of the diagnosis, all that. I thought a copy was sent to Mr. Stockton.
Not that I'm aware of, Judge. I wouldn't, I don't know about that, you know, but one thing I would ask the court to consider, Your Honor, once he gets in the Bowling Green facility down there at the halfway house, we would be able, I think then, I could go down and see Mr. Vincent myself, obtain those medical records from him and bring them back to
Okay.
the court.
I'm willing to go along as soon as I get the medical records.
I can have it sent to Johnny's phone right now if somebody wants to. If
Well,
you could show
here's
us
the thing
medical
about
records.
it. I need the medical records. The Commonwealth needs the medical records and a waiver, a HIPAA waiver, so they can contact the provider and just validate it. And as soon as I get that, we'll cooperate to try to get you where you can get some medical treatment. But without that record, to investigate that, I'm not gonna do it.
Could I ask him what I need to do to get
Go
those
ahead.
records?
Listen, your attorney wants to say something to you, sir.
Judge, what exactly do I need to do to get those medical records as expeditiously as I can and get them to the court?
I can have it. I already have a copy, and I can get it sent to you like ASAP.
Send them to my office and I will transfer them over here sometime tomorrow to Mr.
All right,
Stockton.
like
And we'll
when,
need to send you a release to allow everybody to look at those.
now what they were telling me too, like they really they say if the case is open, that there's still a chance it'll stop me from going. And
I understand what we're dealing with. And I'm willing, if your medical situation is what it's like and you're under the supervision, as you say, and the Commonwealth can document it, we're willing, I'd be willing to dismiss the case without prejudice until you get treatment, to see if you can get treatment. I'm willing to try to get that, but we've got to have, you got to understand that everybody's got a deal. The world's full of con deals, okay? So we got to document it, okay? And once it gets documented, I'm sure the Commonwealth will cooperate and try to get you the treatment, okay? Out of a humanitarian situation. Thank you.
now
Josh, I think we've got what we need. If we can get those medical records, I believe the judge is saying that he will.
I'll consider that, but you need a waiver, Johnny. You need to get him a waiver. Okay, thank you very much.
Hey, Johnny, how long would it take to come up with a plea to get this done with anyway? Just to get this over with, regardless of the medical situation.
What's he charged with?
There is trafficking and.
No, it was possession, strangulation, and possession of a firearm.
Yeah.
But
Okay, well, you have to talk to your attorney about that. You brought the firearm and strangulation stuff. You're not helping yourself with me any. I can tell you that right now. Okay, it's nice talking to you. Have a great day.
Thank you, Judge.
Okay, disconnected. No. Set a court date on that for June the 20th. Next court date, June the 20th. Okay, Leslie County Detention Center. Could someone call Leslie County, see if they've been pretty good about getting on, but we've had such an unusual day today. Okay, do we have anybody else here that's live? We have James Dockery or Gillespie have not been processed yet. They're the last two on the live docket. Let's go to Barron County.
You don't have panel line here for sentencing. Well, I forgot.
I hate to tell you, she's not on your list. Originally probation and parole did not do a PSI, had told me they would not be able to get one by today, so I had her continued out to the next month. And then yesterday afternoon, I got a PSI email to her. She wasn't added back to docket. I don't have a copy of that.
We have the PSI, she reviewed it. But I mean, I'll do whatever you say, it doesn't matter.
Let's bring her back next month for sentencing.
She's in drug court and it's under their supervision.
Does she need to be sentenced?
No, she's already actively in drug court.
Okay, well, let's bring her back, on, May 16th for sentencing.
Mr. Newberry, we have the calendar pulled up now for the lab, and the lab is available on the 7th of June.
And Judge, I'll complicate this even more. Mr. Newberry tells me that he is hiring private counsel.
No, he's not. He's gonna be here on the slate for a trial with you. I'm not gonna relieve you. You know, I'm not gonna fool with you, man. This is no joke. You say you don't open your mouth, okay? You come up here and say you're gonna enter a plea. Get this, we come up and get a trial date, and you're in the custody of the jailer. That's where you are, okay? I'll put him on the docket. You're relieved. He just fired you. And he'll be here on May the 16th. I'm not gonna have these little childish games played around here. Thank you very much.
Take the trial off.
The trial is off. We'll come back next month when he has a lawyer.
I'm fine with that. Judge.
Yeah. Okay, now let's go to the Barron County Detention Center. Barron County?
Yes, Your Honor.
Okay. Dalton, Birdwell? Commonwealth versus Dalton, Birdwell, 22 CR 0051. Are you Dalton Birdwell?
Yes, Your Honor.
Okay, you're here on a shock probation revocation. What does the Commonwealth have to say?
Yes, Your Honor. This was our motion to revoke shock probation based on some new charges that Mr. Birdwell has gotten.
Tell us what they might be.
Shoplifting, unlawful drug paraphernalia is what the most recent in Tennessee.
Okay, what you want to stipulate to this?
Judge, unfortunately, I didn't know Mr. Birdwell was in custody until yesterday. I've not had a chance to speak with him, so I can't stipulate.
Okay, let's set it off till May the 16th. Your next court date's May the 16th, Mr. Birdwell. Stephen Brown. Commonwealth versus Stephen Brown, 23 CR 0063. Are you Stephen Brown?
I am.
Were you born in 1980, Mr. Brown? You born in
Yes.
Last four digits of your social security are 0396. Is that correct?
Yes, sir.
Okay. You're here on a pretrial on 23 CR 0063 and 24 CR 0005. What does the Commonwealth have to say?
We're needing a negotiation day on this.
Negotiation day for May the 10th, and the next court date is May 16th. Your attorney's going to be over to see you, and you'll be transported probably over here on May the 10th for a negotiation to see if you can wrap both of these up. Mr. Brown, okay?
Could I address one issue quickly in his case,
Yes.
Your Honor? Your Honor, his mother had put up a house for a bond. Of course, he is in jail now, and that would not be needed to stand any longer. I believe it was her husband that has passed away. They're needing to sell that to pay some bills and things, and I was wanting to ask.
Well, I'll release the bond if she's, you have no objection. He's incarcerated for the bond being released. Okay, I'll be glad to sign it and release the bond.
And Judge, one last thing, he has some medical issues. Would the court consider allowing him, if we done an order to get his medical treatment concerning his back? And I've not been involved in.
You need to present that to the Commonwealth And I'll be glad to look at an agreed order for any kind of treatment he's got, that he needs, okay?
Thank you, Judge.
Thank you. David Buck. David Buck, Commonwealth versus David Buck, 24 CR 0017. Are you David Buck?
Yes, sir.
Okay, you born in 1982?
Yes, sir.
Last four digits, social security number 2125.
Yes, sir.
Okay, this is a motion to revoke your bond. What does the Commonwealth have to say in this?
We're prepared to introduce that.
You come around here and tell me what you've got and see if they're gonna stipulate. What do you allege that?
Mr. Buck, Your Honor, was involved in a chase by the Kentucky State Police. Mr. Buck failed to provide a registration. Mr. Buck's, your very young daughter was in the back. Where is there?
What's
Mr.
the
Buck had
underlying,
glassy
what's
eyes,
the- what
droopy
is,
eyes,
what is the underlying charge?
charged with DUI.
Not on this, not on what he did to revoke. What's the underlying charge in this case?
Oh.
What's he out on bond
I
on?
don't know, Judge.
Fleeing, evading, Your Honor.
Fleeing and evading.
And he flee and evaded again?
This time he got DUI.
Okay. I just want to know what you're trying to revoke his bond on. What did he do for me to revoke his bond?
He got a new charge,
And what was the new
a
charge?
DUI.
Just a DUI, it wasn't a fleeing, evading or anything?
No.
Okay. Now, what do you have to say about that? You gonna move over here?
We would stipulate, Your Honor, that he got a charge, not to his guilt of the charge, but yes, he did get a new charge.
Okay, was it, officer, did it involve alcohol?
No, Your Honor, it was drug related, Your Honor.
Okay, did you find any drugs on him when you
Did not find any drugs on him, just the, or after I stopped the vehicle, indication of drug use, and then did field sobriety on the subject. And based upon my investigation, arrested him, charged him with DUI, controlled substance, Your Honor.
And Your Honor, I have no way of refuting what his statements is. However, I would ask the court to presume Mr. Buck innocent until his blood work and things like that comes through, due to the fact that there were no drugs found on him. There was no alcohol.
It's
found.
pending in district court?
It is, Judge.
Okay, well, I'll just hold him. I'm gonna hold him and we'll see what happens in district court.
Well, you would not hold him and
No.
see what happens in district court? That would be our request, Judge.
Well, I mean, you could file, they've charged him with a bond violation, okay? Now, if you want to have a hearing on the bond violation at some juncture, we can go up and he can testify and I can see what this officer says, but that would be double adjudication. It will advance through district court. And when is he been scheduled to be district court? You see, there are two or three things that really gall me, and a couple, three more have been added today. But something that really gets me is somebody that has a weapon while they're out on bond, or while they're a convicted felon, or someone that's driving a motor vehicle under the influence while they're out on a bond. I don't like that. It's always been my fear, and I'm pretty easy on bonds, Mr. Bell. I believe that, but now it's my fear somebody run over a school bus and kill about 50 people, and they'll ask me, well, why did you let that guy out on a bond? So he's gonna stay in jail. It seems like to me there's more than probable cause to believe that he was in a bond violation. We'll just see what happens in district court. Okay? Thank you very much. Kelsey Cox. Kelsey Cox. Are you Kelsey Cox?
Yes, sir.
This is 21 CR 0022. Ms. Cox, were you born in 1992?
Yes, sir.
Last four digits, social security number 9782.
Yes, sir.
You're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Yes, Your Honor, this is our motion to revoke and impose sentence. Miss Cox here I believe she was arrested and charged in Wilson County, Tennessee, on Christmas Day with, drugs. And that's
Possession
our,
of drugs.
yes.
Judge, what I'll say for Ms. Cox is she's been in rehabilitation in Tennessee at We Do Recovery. It was possession of drugs. In lieu of revocation, we're asking that she be permitted to go back to We Do Recovery in Tennessee.
I doubt if they want her back.
Yeah, if she is absconded down there as well, so I don't know if that's gonna be a. they'll
Well,
accept her back.
she's stipulating to the possession of drugs, I guess.
Judge, very similar to Mr. Bell. I mean, it's a charge. She's not been convicted of that charge yet. Or she's presumed innocent.
Bring your testimony on. You raise your right hand. Swear the testimony about to give is the truth, the whole truth, nothing but the truth.
I do, Your Honor.
Okay.
State your name for the record,
Chase Collins, I'm the probation and parole officer here in Monroe County.
and as, your role as a probation and parole officer, were you, supervising a Kelsey Cox?
Yes, supervision began on November 10th of 2022. We transferred her case to Tennessee on December 27th of 22 for supervision purposes. On 8/14/23 down there, she was positive for methamphetamine. And they wanted her to attend the treatment at Buffalo Valley Treatment Center. On 9/26, she successfully completed that rehab and she remained in a sober living home there. On 1/5/24, at approximately 8 a.m., when the offender reported as instructed to the Wilson County Probation and Parole Officer, a drug screen was conducted, tested negative. The offender appeared to be in good spirits despite the new charges she picked up at Christmas. She was given a report date of 1/17/24 for her yearly assessment. Later that afternoon, I received a call from Angela Abrams, head of the Freedom House Ministries, who stated the offender left a note on her roommate's bed stating, "I'm just not done getting high yet." A copy of this note will be attached. Mr. Abrams' father stated that the offender's belongings were gone from the residence and her phone appeared to be off. They did do a home visit at 710 Rosa Drive to confirm the offender had indeed left the residence. Contact was established with two roommates who also confirmed that she had left but had no idea where she had gone. That officer texted the offender instructions to report to the office on 1/8/24, 8 a.m. The message listed as read, it says, but no reply was sent. I attempted to call the offender on 1/5, 1/8, 1/9, and 1/8/24. Officers Barrera and Robel went to her sister's house where she resided prior to the Freedom House at 221 West Woodland Street in Watertown, Tennessee. Contact was made with a female at the residence who stated they had not heard from the offender in over 2 weeks. They thought she had gone to Nashville. A clear report was requested. Antioch was listed as the last known address. Officers went to that location on 1/9/24. Contact was made with a male resident there, stated she did not know a Kelsey Cox and seemed hesitant to answer any further questions. He refused to identify himself and shut the door on them shortly after. Phone contact was established with V. John, her last known employer, on 1/9. Per HR, the offender quit on 12/24/23. Offender reported working for a cleaning service after that, but never clarified a business name or location. An arrest check was conducted. No new arrest appeared to have occurred. At the time of this report, the offender's phone continues to go straight to voicemail and no contact has been established.
So she got a new charge on Christmas Day of 2023, and then she went to another sober living facility, and then she left there in January, absconded from it.
Yes.
I have no other questions.
How is it that she's in custody now?
We issued a warrant, placed her in NCIC for the absconding.
And they picked her up in Tennessee?
Yes.
And did she waive extradition back up here?
I don't know.
She's here, so she
Yeah.
must not show.
So I guess she did.
Yeah, okay. You have anything?
I do. Officer, do you know where she was picked up on the warrant? Is that?
No, I have no idea.
And the violations and sanctions that you had talked about, that Christmas Day incident, is that the basis for the revocation or is it what you just talked about, the non-reporting?
there was a violation report filed, referring to the possession of the meth, the unlawful prescription, possession of unlawful prescription trazodone, possession of drug paraphernalia, and possession of unlawful prescription, tromethamine. And the warrant was actually issued, when she caught those charges at Christmas. I was in contact with.
But you, since then, you had an
Yes,
absconding.
yeah, she absconded just right after that.
Okay, you have anything else?
No, you're.
Okay. I'm going to revoke the pretrial diversion order, pre-sentence investigation report to be done by probation and parole. We'll schedule sentencing on May the 16th. And if you have any extenuating circumstances about this woman, you can present it then.
Yes, Your Honor.
Okay.
Your Honor,
Amber, your attorney will call you. You better not say anything about incriminate you. Amber Crow. Amber Crow. Are you Amber Crow?
yes, Your Honor.
You born in 1997?
Yes, sir.
Last four digits, social security number 1582.
Yes.
This is 24 CR 0001. You're here for the purpose of arraignment. You previously, have you had the Department of Public Advocacy before the Public Defender's Office, or do you have an attorney?
I had a public defender when it was downstairs.
Do what?
I had a public defender when Christy was on the case.
Okay, well, I'll continue that appointment. You have a right to remain silent. I'm going to read the charges against you, okay? The grand jury of Monroe County has returned indictment charging you with criminal abuse in the first degree, a Class C felony, and strangulation in the first degree. I'm not going to ask you whether you did those things. I'm just going to ask you if you understand what the charge is.
Yes, sir.
Okay. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving a pretrial motion?
Yes, Your Honor.
Okay, we'll schedule a negotiation day on May the 10th, the next court appearance on May the 16th. And Ms. Crowe, I'm assigning a reciprocal discovery order. The Commonwealth has to provide you with evidence they have in your case so that you may prepare for your defense. Your attorney will be over to see in preparation for your negotiation day. Both of those on May 10th and 16th are at 9 a.m. the condition of your bond, okay? Thank you.
Yes.
Thank you very much. Hershel Hammer. Hershel Hammer. Commonwealth versus Hershel Hammer. 23 CR 0083, 24 CR 0025. Mr. Hammer, were you born in 2005?
Yes, sir.
Last four digits of your social security number 5631.
Yes, sir.
You're here on arraignment on 24 CR 0025. You have a right to remain silent. Your attorney is here present. The grand jury of Monroe County has charged you with wanton endangerment in the first degree. Another wanton endangerment in the first degree. Unlawful imprisonment in the first degree. Theft, unlawful taking or disposition. Fleeing or evading police in the first degree. Criminal mischief in the first degree. And reckless driving, as well as operating a motor vehicle on an expired license. You understand those charges?
Yes, sir.
Counselor, do you acknowledge the identity of Mr. Hammer? Receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Mr. Hammer, I'm signing a reciprocal discovery order here. Requiring the Commonwealth provides you with information concerning your defense. You'll have a negotiation day on May the 10th and the next court days on May 16th, both of them at 9 a.m., both of them conditions your bond. You need to prepare a transportation order if you want to, okay?
Yes, Your Honor.
Thank you very much. Hershel Hicks, Heather Hicks, rather. Heather Hicks. Are you Heather Hicks? This is 18 CR 00180. Ms. Hicks, were you born in 1980? You need to speak up.
Yes, sir.
Okay. The last four digits of your social security number 5617.
Yes.
This says this is a motion for shock probation. What do you have to say?
That's correct, Judge. That's my motion. I just filed it early this week. The Commonwealth didn't have a chance to pull the file, so we've agreed to pass this 1 week and take up the shock motion in Cumberland County on the 18th. Excuse me, 25th.
We're gonna hear your case in Cumberland County, so you won't have to wait till next rule day is what they're saying. So it'll be next Thursday?
Yes, Judge.
Okay. So do you want to transport it or?
I'll do a transport order, and Heather, I'll be over to talk to you.
Okay, thank you.
Yeah. If there's an agreed order or something by then, you won't have to transport it. Okay.
Certainly, Judge.
Christopher Hilt, Commonwealth versus Christopher Hilt. Commonwealth versus Christopher Hilt, 20 CR 00056. Are you Christopher Hilt?
Yes, sir.
You born in 1988?
Yes, sir.
The last 4 digits, social security number 8891.
Yes, sir.
Okay, you're here today on a pretrial conference. What does the Commonwealth have to say?
I think we're wanting to set a trial date in this case.
What is the charge?
It's tampering with electronic monitoring device. Judge, we've tried to plea, but the Commonwealth will not accept a plea and allow Mr. Hilt to make payments.
What was the plea offer?
To make actually the offer was $1,500 and they would dismiss charges.
It's not a plea.
It's not a plea, $1,500 and they would dismiss the charges. And Judge, we've offered to enter a plea and make payments and it's been refused, so
I'm not for sure, Your Honor.
Mr. Hill was kind of fine.
I think that's the fear, is that he won't make the payments, he'll leave.
How much is owed? $1,500?
$1,500.
What was the plea agreement?
Judge,
what did you offer on a pretrial diversion, or is he eligible for a pretrial diversion, or?
Judge, they offered dismissal and for $1,500.
Can't pay it. Okay, so I'm trying to get it where he can make payments.
We've not received a payment offer.
Well, that's what I asked him.
I don't think Mr. Stockton is willing to accept.
Well, surely do a 5-year pretrial diversion with him making $100 a month payment, and if he doesn't, he can go to the penitentiary. The guys either get a trial date or do a pretrial diversion. If he gets a trial date, he's going to get convicted, and you probably never have a shot at getting the money. So I will continue the case until May the 16th. You understand what I'm saying?
Hands are tied.
Yeah, our
Your hands are tied.
notes say prisoner money, so I don't know.
Well, I'm not going to do prisoner money.
Yeah.
You know, I mean, I'm going to tell you what, if we have a trial, just because he didn't pay, I'm probably going to probate it and then give him a chance to pay it. So it'd be better to give him a pretrial diversion if he's eligible and see if he can come up with a lump of money, maybe $500 or something to make a down payment.
Yeah.
So you need to talk to your client to see what kind of payment arrangement.
Please reconsider, Judge, and want to offer him a pretrial diversion.
What a wonderful reconsideration, okay? So you need to get a payment agreement with them, and we might even hear it over.
And that's what I was going to say, Judge. Since I've got to go over and speak with Miss Hicks anyway.
Mr. Hill, I'm going to explain something to you with your lawyer here. You're going to be paying for that device. Okay, they're going to offer you a pretrial diversion. If you meet up with that, pay for the device, and don't do any other crimes, you won't even have a record on this. You understand what I'm saying?
Yes, sir. I got one question for you. If you don't mind, I just have one question. Is there any reason why the prosecutor would have a problem with me security bond? I have no reason to run from Kentucky. I didn't.
Okay, you're not what they don't. This is not a bond negotiation. If you can come up with $1,500 to pay for the thing, they're willing to dismiss the charge.
Well,
wait, don't say anything else. You listen, because you might say something that'll incriminate you. Okay, So what your lawyer is gonna come over, if you can't come up with $1,500, they're gonna offer you a pretrial diversion to let you make some payments and then get out maybe even next week to make payments. But they're afraid that you got rabbit blood in you and you're gonna take off, okay? And they won't get their money. So your attorney will come over and explain that to you. I'm trying to help you, all right? Trying to help you. But you gotta help yourself on this stuff, and getting a bond and getting out and not paying, it's not gonna happen right now, okay? Okay, your attorney will be over, talk to you in the next day or so. Thank you.
Yes, Your Honor.
Dustin Jesse.
Warren County, day 4 years ago, Your Honor.
He's in Warren County Jail, so. Has he got charges over there? Why was he?
I think there was something happened in his marriage.
Okay, well, we'll just have to continue his pretrial conference. Why don't Commonwealth want to check to see about him? Dustin, what's he charged with?
Judge, this is, he was the gentleman that had the episode after sentencing. He was Mr. Garrett's client.
Yeah. Well, it seems like he continues to win friends and influence people if they transferred him to a different jail. What are we gonna do about him as far as getting him in front of the court? Is there an offer on the table for him or anything, or y'all want him for negotiation?
Judge, this is in negotiations. I think part of the issue, yeah, there's outstanding labs, and I think the Commonwealth has also did a request for some hospital records.
You want to put him on May 10th?
That's fine, Your Honor.
May 10th for negotiation and the 16th, and you do a transport.
Yeah.
Well, I think that'll be,
He'll need to be transported because I can't get.
okay.
on Zoom.
No, they never.
That's the one that doesn't like to, so are you
Yeah.
making that?
Courtney Mabry or Mabry? Is it Mabry? Courtney Mabry. Commonwealth versus Courtney Mabry, 23 CR 0020. Miss Mabry, were you born in, is that how you say it, Mabry or Mabry?
Maybe, Your Honor.
Mabry, were you born in 1993?
Yes, sir.
Last four digits Social Security number are 9966.
Yes, sir.
On a pretrial conference, what does the Commonwealth have to say?
We have a diversion plea.
Great. Ms. Mabry, a motion has been tendered that says you wish to enter plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, sir.
Plea freely and voluntarily given. Is this plea freely and voluntarily given?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
We discussed this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
You review the evidence the Commonwealth has against you. Do you believe you're fully informed about your case?
Yes, Your Honor.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know you understand those rights. I'm going to go down through your rights, and at the end, I'm going to ask you if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth prove beyond a reasonable doubt that you're guilty charge against you. Understand by entering your plea today, you give up all those rights. Do you understand that?
Yes, sir.
I may consider the Commonwealth's range of penalties a recommendation, but I may apply a range of sentences allowed by law. I don't have to accept it. In the event that I don't accept the recommendation and want to do something harsher to you, you have a right to withdraw your penalty and proceed to trial. Do you understand that? Now,
Yes,
I'm going
sir.
to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No.
Do you have any felonies in the past 10 years?
No, sir.
Are you currently on probation?
Yes, sir.
You're not on probation, are you? Are you?
No, sir. Not of my knowledge.
Well, when was the last moment that you were on probation?
In Tennessee.
When was that? When, are you still on probation in Tennessee?
Yes, sir, Your Honor.
What do y'all have to say?
Yeah, Judge,
I guess pass it to negotiation day for them to, for us to make sure that she actually qualifies for diversion. We have to negotiate another plea offer.
I would expect no less today.
and
Her
Judge,
case is passed over for negotiations on May the 10th to reappear here on May the 16th to make sure you clarify what the situation is if someone is on probation in another state. I believe I know what the answer to that is. Well, they'll be over to see you, ma'am.
Yes, sir.
Titan Neal. Titan Neal. Are you Titan Neal?
Sir.
You born in 2001?
Yes, sir.
What are the last four digits of social security number?
6027.
You're here in 23 CR 0060. I understand this gentleman wishes to enter a plea. Is that correct?
yes, Your Honor.
It's a felony plea.
It is, Judge.
A motion's been tendered, sir, that says you wish to enter a plea today. Are you currently under influence of drugs or alcohol?
Sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 23 CR 0060?
Yes, sir.
Is your judgment impaired today in any way?
I'm sorry.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
And reviewed the evidence the Commonwealth has against you, believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I accept pleading guilty, I need to know that you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering this plea today, you give up all those rights. You understand that? I may consider the Commonwealth's recommendation. I may apply any range of sentence allowable law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await a pre-sentence investigation report to be done by probation parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. Now, what is the Commonwealth's recommendation? Speak up, please.
Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, probated for 5 years, supervised. The defendant shall enter and complete the Monroe Specialty Court. The defendant is currently incarcerated and shall be released from incarceration on the morning of specialty court orientation. He shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that your understanding, sir, of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
And you know that you know that your constitutional rights, which I previously explained to you, have been waived. Still, your desire to give up those rights allow the court to fix your punishment within the range permitted by law.
Yes, sir.
You understand that if you have any future felony convictions, that this could be used to enhance the range of penalty under persistent felony offender law. Do you understand that?
Yes, sir.
Is that your signature there?
Yes, sir.
Okay. I'll accept the plea order pre-sentence investigation report to be done by probation parole. Have a sentencing on May the 16th, and they will proceed with the drug court. And as soon as you get a schedule for drug court orientation, we'll allow you to be released and start into that program. Okay?
Sir.
Okay, thank you. Larry Norris. Larry Norris. Are you Larry Norris?
Yes, sir.
Have you born in 1992?
Yes, sir.
And the last four digits, social security number 1833, right?
Yeah.
We're here on 23 CR 0078, and you have a motion to allow a doctor to talk to Mr. Norris. Is that right?
That's correct, Judge.
Is that correct?
Yes, Your Honor. He's unavailable today to the doctor, but Jesse was wanting to move the case to Cumberland County next week.
So the doctor's already talked to this gentleman.
That's correct,
And
Judge.
you want him present?
I don't need him present, Judge. I know in past you wanted an agreed order with him signing, but since this is opposite and not competency, I didn't know if the court still wanted that.
Yeah, I mean,
They say he is competent or what?
no, they
No.
said he's not.
Okay, well, we'll schedule him for what's the date on coming, Ken?
25th.
Okay, they're gonna be, your lawyer's gonna be talked to you and so you won't have to drive all the way over there to Burkesville. We'll have you on the Zoom again next week. Okay, sir?
All right.
Okay, thank you. We're gonna have just a short 3-minute break here.
Oh, Josh, did y'all get a warrant of arrest? Josh, you would think.
He is not, they're not.
I can't put a hold on it. Oh, so was Dave. He's.
He's not ours. He's not gonna let him go anywhere. I guess we put a hold on it. We just wasn't going anywhere.
So Judge, you just didn't issue her?
Didn't sound like- I don't-
Yes.
Hell, yeah. Fine, yeah. Where we get out here?
Yeah, I'm like.
You'll be in good.
Bruce brought one actually.
I like Berkey, but I think I went there one time and they put it off.
Thank you.
Nice to meet you. It's sad that it's on the last day.
It's all right.
Was it just two or there's?
I don't know about.
Yep, that was
Hold on,
mine.
hold on.
Put the sauce on it afterwards. If you need sauce in it.
No,
No.
and you have those.
That's an up north.
I got those.
Put
I got
sauce in
those
it.
too.
I cook it in my crock pot.
Perfect.
Don't cook that no crock pot.
So I don't want sauce. I don't want my barbecue to be saucy mess. I want,
You want it soaked in.
yeah, I mean, I'll put some on it, but, but.
That sounds good. Yeah.
Don't put a signature
I
on
mean,
it.
I like pulled pork. Yeah.
I was gonna say.
I don't like it like that.
Roy's barbecue, they make it for it.
Yeah, see, that's what I
You
want.
like Roy's barbecue? In Logan County? Oh my gosh.
The big man in Glasgow was do some of the best around. I think.
Okay, let's come back to order, please. Let's go on the record. Jesus Padella. For sentencing. This is Padella, the junior, right?
Is it paying him?
Oh, every penny of it. What do you think?
Commonwealth versus Jesus Padella. You're Jesus Padella?
Yes, sir.
Here for sentencing today. I want to make sure I've got the correct Jesus Padella. You were born in 2002?
Yes, sir.
Okay. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yeah,
Okay. Is it substantially correct?
correct.
Upon a plea of guilty under docket number 22 CR 00105, the theft and unlawful taking, you shall receive a sentence of 5 years. Upon plea of guilty under 23 CR 0059 for burglary of 3rd degree, you receive 5 years. Upon plea of guilty, indictment number 23 CR 0059 for criminal mischief, you receive 5 years. 2 5-year sentences under 23 CR 5050 0059 shall run concurrently for a total of 5 years. The 5-year sentence shall run consecutive to 22 CR 105 for a total of 10 years. Probated, however, for 5 years. Is that correct?
As far as it went, Your Honor, it was probated on the basis that he was going to make a payment of $9,000 before sentencing, and he hasn't.
And Judge, I'll agree with Commonwealth. That's we were here about 2 months ago, back in February, for sentencing. Jesus had not tendered the balance, and you were going to give him 60 days to see if that circumstance had changed. And I was just informed by the Commonwealth that that has not.
Yeah, in the plea agreement, it says defendant is currently and shall remain incarcerated until the restitution is paid in full. So, okay, well, I'll just not do the probation and sentence him then to 10 years.
Yes, Your Honor.
Okay. Now, he can get counsel and take a look at shock probation if he wants to, if he can come up with the money. Restitution order is still there and probation shall continue until the restitution is paid.
Yes, Your Honor.
Is there like a HIP or a ankle monitor that can payment stored?
You need to talk to your attorney.
All right.
Okay, thank you.
Court costs.
Court costs are, and this is how much? $310. Which I'm gonna waive since he's gonna serve 10 years. Joshua Perry. Joshua Perry. Are you Joshua Perry?
Yes, sir.
You born in 1991?
Yes, sir.
Last four digits, social security number 5880.
Yes, sir.
You're here today in 22 CR 0033 on a pretrial diversion revocation. What does the Commonwealth have to say?
Judge, if I may, while the Commonwealth is getting their notes together, I discussed this with Mr. Stockton and anticipate them talking about an alleged failure to appear and absconding, but records would show that Mr. Perry was actually incarcerated in Macon County, Tennessee during the alleged failure to appear, and I believe some of the duration of the alleged absconding. So I just wanted to make the Commonwealth aware of that.
Well, would that violate his pretrial diversion, having done something down there to get incarcerated for? I don't know whether that proves his situation or not.
Yeah. Thanks, Scott.
Looks like the defendant is gonna have to depend upon Mr. Hunley's mercy.
Yeah. Chase Collins.
Call a witness here. Swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Could you get us the can note version of what's going on without verbatim recitation? Answer Mr. Hunley's question. Mr. Hunley's question is what's up?
Mr. Perry, a client of yours,
He was for a short period of time. Supervision began on 8/18/22, and he was transferred to Tennessee for supervision on 9/26/22.
and what records, what do you have in the records that indicate how he has fared under your treatment?
Documents received from Tennessee. On 10/19/22, Mr. Perry was arrested and charged in Macon County, Tennessee for domestic violence. It says, I, Deputy Jason, was dispatched. On my arrival, I spoke to Ashley Wilkerson, who stated that her boyfriend, you don't care about that, okay. On 11/5/22, Mr. Perry was arrested and charged in Macon County, Tennessee, for domestic assault, violation of order granting bail. On 11/10/22, Mr. Perry was convicted in Macon County for misdemeanor domestic assault. On 5/16/23, Mr. Perry was arrested and charged in Macon County, Tennessee for the following, which was aggravated assault domestic, And on 6/17/23, Mr. Perry was charged in Sumner County, Tennessee, for aggravated domestic assault and felony reckless endangerment. And then for absconding, on 5/16/23, Mr. Perry was arrested and charged with aggravated domestic assault, 6/13/23. The agreement was entered to dismiss the charge after 6 months of good lawful behavior. 6/15, we notified. I don't understand what the officer's saying here. On 6/17, subject arrested and charged with domestic violence, reckless endangerment. 7/20, notified us of that. 7/25, fair to appear, was issued in Macon County, maybe a warrant by FTA. On 7/27, they began the absconder
What year are we
investigation.
talking about?
7/27/2023. They began absconder investigation, made multiple attempts, at least 4, to contact
How
the
many
phone.
more things do you have there?
I'm almost done here.
Yeah.
And your supervision began on Mr. Perry.
8/18/22.
Everything that you've described here today has occurred subsequent.
Yes, in Tennessee, yes.
That was your answer. Okay.
So officer, again, you were reading notes from Tennessee, correct?
Correct.
So you weren't the one that was supervising.
I'll take judicial notice that he was.
Thank you, Judge. And you talked about on some of those assault charges that they were gonna be dismissed. What was that?
Bear with me here.
Was one of them if it was.
I think we're talking about on 11/22.
Yeah. That was one that said if he lawfully acted for 6 months.
Yeah, that is correct. It's on 6/13/23, an agreement was entered to dismiss the charge after 6 months of good lawful behavior, but it doesn't say exactly which charge that was.
Okay, so, but again, that's after those assaults that you were talking about in May
Correct.
and.
Yeah.
That's all I have.
Okay, do you have anything else?
I have nothing further here.
Okay. Your client wish to testify?
Mr. Perry, is there anything you want to tell the court?
Yes, sir. During all that.
Hold on.
Wait. You raise your right hand? You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir, I do.
You now ask the question.
So, Mr. Perry, I want to start with those incidents in June and May of 2023.
All right.
What was the result of those charges?
I took probation for one domestic. I got out, and then me and my ex-wife got to arguing again. She called the police, which that's when the retirement came in. And then I was on 11/29 probation in Macon County.
Did you take any classes as a result of those charges?
No, sir.
Been to any rehabilitation?
No, sir.
And as far as the time that you were in jail in Macon, Tennessee, when was that?
I got transferred to Macon County in the beginning of August of 23.
Been there, or did you get out of jail anytime since August of 23?
No, sir.
So you've been incarcerated somewhere, Tennessee or Kentucky, since August?
Actually, July.
Those are all the questions I have. Thank you.
Just one question. Mr. Perry, you indicated that you had twice been probated for aggravated assault in Tennessee?
No, sir, just once.
Okay, did you plead guilty to that charge?
Yes, sir, I did.
I have nothing further.
Well, I'm going to go ahead and revoke the pretrial diversion on Mr. Perry and I'll order a pre-sentence investigation report on May the 16th. of, for the sentencing on that. And then at that time, you can make any argument that you have concerning any extenuating circumstances that Mr. Perry might have, or whether they ought to be probated or not.
Yes, Your Honor.
Because, I think with the guilty plea to that felony down there, I have no choice but to revoke the pretrial diversion, okay?
Yes, Judge.
They'll be over to talk to you and explain in detail, but we'll
Never signed a felony.
do what?
I've never signed a felony. Everything I signed was misdemeanor.
Well, okay, well, that's what they'll look at in the pretrial report. Okay, that the pre-sentence investigation report, and you'll get to talk to probation and parole officer, explain your side of what happened, and then they'll go down and check the records in Tennessee, and then we'll be back here on May 16th to try to resolve the thing, okay?
All right.
Thank you very much. Jamie Piercy. Talbot versus Jamie. Are you Jamie Piercy?
Yes, Your Honor.
This is 20 CR 0021. Were you born in 1987, Mr. Pierce?
Yes, Your Honor.
What last four digits of your social security are 9146. Is that right? We're here on a shock probation revocation. What does the Commonwealth have to say?
Yes, Your Honor, I believe a hearing was already held last month and it was found sufficient evidence to revoke him. But you wanted to see if he had made any payments towards his child support because the underlying charge is for flagrant non-support.
Yeah.
And we have checked that and there's not been any payments made since October of last year. And the arrearage is about 8,000.
And Judge, that's correct. I'm not going to, just to remind the court briefly on a few of the facts from the hearing. Mr. Piercy was an individual, was in specialty court, which was the basis of the revocation. He was terminated from specialty court because he was unable to hold a job. There was testimony about his vehicle situation. Judge, I've discussed this case with Mr. Piercy. Can't squeeze blood from a turnip. I know the court, Commonwealth wanted to see what payments he could make toward the arrearage, and he's telling me that's not. He can't do anything. Certainly, if given the opportunity to make payments, but Judge, the connection on this is Mr. Piercy did not pick up new charges. He was terminated from specialty court for an inability to work.
I'm always willing to take constructive suggestions. Why don't you give me a constructive suggestion on how we can get this turnip to pay his child support?
I can file taxes as soon as I get out of here, pay a lot of it. Over half.
You can file taxes.
Yes, Your Honor.
You can file taxes from there. Your attorney will be over there to talk to you. I don't know what I have to do.
The job is.
I gave y'all, listen, I gave y'all this time. 60 days, was it?
30. We were here last month.
And you hadn't done anything. So I don't know what to do with you, Mr. Piercy. They say you can't get blood out of a turnip, but I can bury a turnip, for about 3 or 4 seasons. And that's, give me a reason to, how much is the child support arrears?
I think it's about 8,000.
Okay. Why haven't you made arrangements? What kind of tax return are you? Did you pay any taxes in this last year? 2023?
That's right. Yes, I had a couple of different ones.
I'm not understanding. I can't understand what you're saying. How long were you employed in 2023?
Most of the year.
And who was that with?
I worked for Dollar General Warehouse and Alton. Scottsville.
Yeah. Well, your attorney is going, where are your W-2s at from work?
My wife's got them. I don't know. I've not spoke to her. I don't know how I can I have to get out and.
You're not going to get out. You're not gonna get out to do this, and that. You know, there was an old story about a guy that stole my dog and he promised me he was gonna bring it back. And they said, anybody that steal your dog will lie to you about where they're gonna bring it back. And, you've had all these opportunities to pay this and you haven't. And I'm gonna give you, your attorney's gonna come over to you, talk to you one more time to see if we can get your W-2s or anything. They got these instant pay things you can do now that you can file it and get your instant refund.
If he's in the child support system, there'll be an intercept.
Well, I know, but until he files it, there won't be an intercept.
I agree with that.
Yeah. So we'll just see, let somebody calculate. We have to know if there's anything to intercept first, Mr. Hundley. That's what I'm trying to get him down to. Okay. I'll schedule you to be back here on May the 16th. Jose Robles.
Yes.
Jose Robles.
Sure.
CR 0015, Jose Robles.
Yeah.
Born in 1996.
No.
Last four digits, social security number 6935. Mr. Garrett, you represent this gentleman. We're here for a pretrial conference. I know you haven't reached an agreement.
We have not reached an agreement on
Yeah.
this case. And I don't even think I've got all the discovery yet.
Did y'all give him all this? What's the charge this guy's on?
Murder, Judge. Well, attempted murder.
It's not murder, is it?
Attempted murder.
Yeah.
Is this over there?
Yes.
It's murder.
It's murder.
Murder and an
Murder
attempted.
and attempted.
Murder and an attempt to murder, sorry.
You don't know what he's charged with?
I do, Your Honor.
Okay. Not very reassuring if you
There
know.
are 3 additional indictments today, I understand, for 3 counts of wanton endangerment arising out of this incident.
Okay, well, let's just reschedule this. There's no reason to do a negotiation on this thing.
Too premature, Judge.
Yeah, well, I don't want to be premature. You want to schedule this for June the 20th? That'll give you time to get all the discovery in. Is that okay with the Commonwealth?
Yes.
Yes.
What is your negotiation on June the 20th?
We don't have one yet. We don't have one.
You don't have one in June?
Actually, well, Judge, we were going to use that June 7th date.
Well, didn't we schedule trial on that?
Actually, we didn't.
We didn't because your guy pulled out, right? Well, June 7th is available. See, all things work to the good.
That'll be fine.
Good book says. June the 7th. Okay, your attorney, Mr. Robles, will come over. There's some additional charges the grand jury's bringing today that are less serious than the ones you face, but are serious enough. Evelyn Shirley, thank you. Evelyn Shirley. Evelyn Shirley. Are you Evelyn Shirley?
Yeah.
We're here in 24 CI 00011. Ms. Shirley, you were born in 1959. The last 4 digits, social security number 4698. You're here for a pretrial conference. Now, if this is a criminal syndicate charge, there must be other people charged also.
Judge, there's an additional, it's an arraignment as well.
Okay.
Well, they're both right. Okay.
It's an arraignment just on the
Syndicate.
city.
Okay.
Arraignment.
You have a right to remain silent, ma'am. The grand jury of Monroe County is returning an indictment charging you with criminal syndicate engaging in organized crime. You understand that you've been charged with additional charge, ma'am?
Yes.
Okay. I've presented to your attorney counselor. You acknowledge the identity of Miss Shirley, receive the indictment, waive formal reading and arraignment, enter plea of not guilty.
Yes, Your Honor.
All pretrial motions. Now, is this 24 CR 0011 the number of accompanying indictments, and this is a subsequent, or is this a new indictment number assigned?
It's under the same indictment.
So this is a superseding or a supplemental indictments, correct? The answer would be yes. Okay. Okay, you want to schedule her for a negotiation day?
Yes, Your Honor.
Negotiation day, May the 10th, next court appearance, May 16th, both at 10 a.m. And if you want a transport order, you'll be responsible. Now, just for the purpose of my edification and information, there are others evidently that are charged with criminal syndicate also. Are all those people scheduled to be there on that date? And do they all have separate counsel, since there obviously will be conflict?
I think some of them have retained private counsel and some of them, the warrants have not been executed as of yet. So I believe that Ms. Shirley is the only one that we have acquired so far.
Okay. Okay, now how many other warrants do you have out?
One more.
Just one. Okay, thanks a lot. Your attorney will be over to talk to you, Miss Shirley. Timothy Shirley.
Your Honor, can I ask for a reduction or something so I can get medical treatment? I got out, been in the hospital for 3 weeks and got out.
Evelyn, hold on just a second. This is Candace from the Public Defender's Office. I'll come over there and talk to you. We have to file a motion for bond to be addressed. So let me come talk to you. We'll talk about what we can do with that, okay?
All right, thank you.
Okay. Timothy Shirley. Are you Timothy Shirley?
Yes, sir.
Okay, this is 24 CR 0028 for arraignment and 21 CR 0058 for probation revocation. Mr. Johnny Bell's listed as the attorney. Is that correct, Mr. Bell?
I had him on the old case, Judge, and, I guess that's why it would be on there on the revocation, but I have been,
You haven't been retained for this case?
no, and as a matter of fact, I've been retained by Chad Shirley, his nephew, which I arraigned earlier today.
Which is a conflict in this case?
It will be, Judge.
Okay. Mr. Shirley, you don't have an attorney right now. So I'm gonna appoint you public advocate for the purpose of this arraignment, and then we'll let you do an affidavit to see if you're eligible for a public defender, okay? Okay, the grand jury of Monroe County, Mr. Shirley, has returned an indictment charging you with criminal syndicate, engaging in organized crime, trafficking controlled substance, and being a persistent felony offender. You understand what those charges are, don't you?
Sure. Yes, sir.
Counselor, will you acknowledge the identity of Mr. Shirley as he has received the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, now we need to get him if pretrial is listening today or monitoring this, you need to get him an affidavit over there to the jail and allow him to fill that out so I can permanently appoint the public advocate's office to represent him in this case.
Okay, Judge, got it.
If he's eligible, okay?
All right, Judge.
Okay, and they'll be over, let you fill this affidavit, see if you're eligible, Mr. Shirley. And once I do that, and I'm gonna leave your appointment in place right now so we can proceed and he won't lose any time on this. So we'll schedule a negotiation on May the 10th. The next court appearance on the 16th, because Ms. Shirley was scheduled for those dates for negotiation. And if there's someone maybe has been served by then, if someone has been served by then that's not served now, y'all need to inform me of that fact, and we'll see if they have an attorney or whatever, and maybe get them there at that negotiation too, so everybody will be present. Your attorney will be over to talk to you, Mr. Shirley, okay? Thank you. Aaron Southworth. Commonwealth versus Aaron Southworth, 22 CR 0072. Mr. Southworth, were you born in 1992?
Yes, sir.
Last 4 digits of social security number 7202.
Yes, sir.
We're here on a pretrial diversion revocation in 22 CR 0072. What says the Commonwealth?
Yes, Your Honor, this is our motion.
You want to come around here, so.
Our basis for our motion for revocation is for a new charge. I believe he was indicted on it this morning.
What was the new charge?
Burglary.
Will, you got any testimony?
We have an officer here that made the arrest or made the indictment this morning.
And Judge, I've actually been over to speak with Mr. Southworth. The issue that I have is there's, my understanding, Nicholas Highland is a co-defendant. I thought he was actually on for, hold on, don't say anything, sir. Thought he was actually going to be on for revocation today also. There was obviously a conflict of interest at the prelim stage to where they had to have different preliminary hearings. Judge, I don't feel comfortable going forward with a revocation hearing when there's an inherent conflict of interest, and
Is he on a bond on the new charge that will be returned today? And I'll set a bond on it.
Correct. So I was just gonna ask.
Okay, here's what I'm gonna do. When he's served with the new warrant, then I'll set a bond, he'll be served with the new warrant. If he can make the bond on the new warrant, what's the underlying charge that he was on pretrial diversion for?
Possession.
Well, I'll probably set a bond just considering that. The new charge will be on what?
Burglary.
Yeah. So we'll set a bond and then we'll,
Burglary first.
okay, and what we'll do is go ahead and schedule a negotiation day in this for May the 10th and the next court appearance for the 16th on both of these things, okay? If he makes his bond on one, he'll make his bond on both. If he can't make it, we'll know where he is.
Yes, Your Honor.
Okay. Your attorney will be over. Go ahead.
Can I ask for a bond reduction on the burden?
Well, we hadn't been served with, you haven't been served with the indictment warrant yet. And when they serve you an indictment warrant, the pretrial people will take a look at your background and that sort of thing, and we'll set a bond at that juncture, okay? And then that bond will require you to appear for negotiations on May the 10th for a negotiation day here in Monroe County. And then on May the 16th will be your next court date, if you make the bond. If you don't make the bond, those 2 dates will stay the same. But we'll look at the bond report that they give to us. So they'll interview you and they grade you on this or that, where you have that failure to appears and that sort of thing, okay? Okay. Thank you very much.
We'll be able to talk to you.
Okay, Christopher Steelwell. Christopher Steelwell.
Yes, Your Honor.
This is Commonwealth versus Christopher Steelwell, 24 CR 0012. Mr. Steelwell, were you born in 1975?
Yes, sir.
Last 4 digits of your social security number, 6497.
Yes, sir.
You're here today for the purpose of arraignment. Do you have an attorney, Mr. Steelwell?
I had one, Bryant Green. I've been in rehab, sir, at the Mark Center. I'm in the middle of a rehab now. I'm in the middle of treatment now.
Yeah, Department of Public Advocacy represented you, so we'll continue that representation. You have a right to remain silent. I'm going to arraign you on this charge, then we'll talk about what's going to happen. The grand jury of Monroe County's returning indictment, sir, charging you with possession of controlled substance, first degree. The EPA is here. Counselor, do you acknowledge Mr. Steelwell's identity, receive indictment, waive formal reading arraignment, enter plea of not guilty on his behalf?
Yes, Your Honor.
Reserve all pretrial motions. Mr. Steelwell, I'm assigning a reciprocal discovery order requires the Commonwealth to give your attorney the information they have in order to prepare for your defense. What's Mr. Steelwell's charges were possession?
It looks like a
What's his
possession.
bond?
The $15,000 surety, Judge.
15 surety?
Yeah.
Okay. That's
Your
pretty,
Honor.
that's pretty low bond, Mr. Steelwell.
When I was in district court, they sent me to rehab, and I've been in there for the last 4 months. That was stipulation of my bond completion.
Your Honor, if we're able to get.
You need to speak up.
Yes, Your Honor, if we're able to get confirmation of Mr. Stillwell being in treatment and his progress there, would the court at that time be willing to release him back to treatment?
If he makes a bond,
Yes, Your Honor.
you know, I'll consider it. Do y'all listen to what they're saying over here? I'd like to have someone from the Commonwealth to participate in this discussion here, okay? Mr. Steelwell was in treatment, they say. But and I don't know whether he made the bond at $15,000 bond in district court. Did he?
I don't have that information in front of me, Your Honor.
5,000 unsecured, Judge.
Okay, well, this is $15,000 dollar bond, and I'll let him go. You know, if the Commonwealth have any objections in going back to treatment, if he makes his $15,000 surety bond. Okay, if he makes his bond, I've got no problem with him going back to treatment.
What's the surety bond, Your Honor?
Somebody has to come in that's worth $15,000 and sign their name. The clerk has to say, yep, they're worth $15,000. They don't have to, it's not like a property bond or anything.
Just somebody has to come in and sign a surety bond?
If they're worth at least $15,000, if they've got a trailer or a house or got a Mercedes or they got just about anything. Do what?
My own home?
Do
Me and my
what?
wife? Me and my wife?
They just come in and bring somebody, you bring anybody in and the clerk will probably approve of 15,000. It's not hard, okay? Okay, thank you.
Yep.
That bond will be conditioned on him going back to rehab. You can make the bond and go back to rehab. Christopher Sutton. Christopher Sutton.
Yes, sir.
Commonwealth versus Christopher Sutton, 24 CR 0007. Mr. Sutton, were you born in 1995?
Yes, sir.
Last four digits, social security number 1321. Yeah, you're here for a pretrial conference. Come around. Tell me what the Commonwealth has to say.
We're needing another negotiation day on this.
What's he charged with?
It's a theft by unlawful taking, possession, possession with a firearm.
And methamphetamine.
Said possession.
Oh,
Well,
and
I
enhanced by.
said that. That's what I said.
Okay, we didn't get it all out.
I was coy with my alliteration.
Mr. Hunley just wanted to hear it again. That's
Right, yeah, Judge.
It's like when
Didn't
if
think
we
you
ever,
understood.
okay, May 10th for negotiation day, May 16th for the next court day. You'll be over to talk to him, explain the situation to him?
Yes, Judge.
Okay, your attorney will be over to talk to you, Mr. Sutton. We got you coming. We'll transport you on the 10th. Come over for negotiation, so you can do that, and on the 16th at 9 a.m. Commonwealth versus Jared Terry. For sentencing. Oh. Hello, Mr. Terry. Were you born in 1994, sir?
Yes, sir.
Last four digits, social security number 6082.
Yes, sir.
We're here for sentencing. Have you had an opportunity to look at a pre-sentence investigation report done by probation and parole?
Yes, sir.
Okay. Counselor, is it substantially correct? You went over it with him?
I did, Judge.
Is there any reason why he should not be sentenced?
No, Your Honor.
For a plea of guilty to assault second degree, the defendant shall receive a sentence of 10 years to serve. He shall have no contact with the victim, receive credit for time served. Because of the length of the sentence, I'm waiving the court cost.
And Judge, just as a point of order, just want to state this on the record. There was an issue that come up last time we were here regarding some firearms that were going to be forfeited. That issue's been resolved with the Commonwealth. I've signed an agreed order, tendered it to Madam Staff Attorney with Dorothy, I don't know your last name, sorry. Morgan receiving the firearms. She's Mr. Terry's grandmother.
If the Commonwealth agrees to it, I won't object to it.
Thank you, Judge.
Okay, thank you.
Thank
Michael Turner. Commonwealth versus Michael Turner, 23 CR 0055. Mr. Bruce Brown's here representing Mr. Turner, and it says a motion for examination. What is this here?
Judge, this was the Commonwealth's motion, but I seconded. I think we need to have a KCPC evaluation done, Mr. Turner.
Okay, well, I'll sign the order. Mr. Turner, They're gonna let a doctor talk to you to see if it might improve your situation some. So, when, is this gonna be an inpatient or what is it gonna be?
Yeah, I would say inpatient.
Inpatient evaluation. They'll be over to see you soon, Mr. Turner. Thank you.
I was wondering why I never got out to the heart doctor. I've been released by you twice and never been released here at this jail. And I've been denied my medication for 11 months in this thing.
What's he saying?
I can't understand him.
Needs meditation.
Let me step away from the microphone just a second. Let me talk to somebody from the jail, okay?
Your Honor, he said that you released him twice to go to the heart doctor.
He was released on an ankle monitor, Judge, but when they came to put the ankle monitor on, this was a case where he could not go back to this property that he was not allowed to be at. And he was saying that he was going to go there, so.
Is he getting all the medical treatment that he needs there? Y'all providing that for him?
We have medical here, yes, sir.
Well, I have not had.
It's just. On, Jason.
Okay, thank you. We'll get this, we'll get the psychiatric examination done. Okay, thank you. Thank you. Abigail Vibert is next, okay?
Well, is my lawyer gonna come see me? I've been denied a phone call since I've been here too.
You need to go come see him. Yeah, lawyer will be over to see you. Abigail Vibert. Are you Abigail Vibert?
Yes, Your Honor.
This is 23 CR 0052. Were you born in 1996, Miss Vibert?
Yes, sir.
This is, are the last four digits social security number 1327?
Yes, sir.
You're here today for a pretrial conference. What does the Commonwealth have to say?
Trial date, Your Honor.
What's she charged with?
And Judge, I know, I think Ms. Gordon Anderson's notes say trial. When I
What is
discussed,
she charged with?
Judge, it's a
It's a
sex crime. I don't have the exact.
Okay, I remember now. Okay.
And Judge, during negotiations on April 5th, Mr. Stockton and I had discussed doing an agreed order for mediation to resolve this case.
I don't have any notes on that, Your Honor.
So I don't want to.
Well, I don't have any problem with that. We're doing a mediation. It won't hold things back any that much because we probably won't be able to schedule anything next month anyway for trial. I think, is this a C that she's charged with or a D or what is it?
Actually, it's B.A.
B.
B.
Yeah. Thus the mediation.
Yeah. Who would you suggest for mediating this?
I was actually discussing with the DPA, I think. Yeah, I'll let you.
Your Honor, our office usually uses Judge Patton for mediations, but obviously we've not been able to speak with the Commonwealth about their preferences regarding
Judge
this.
Patton or Judge Minton, either one. Justice Minton, either one would be fine.
I believe would be.
Okay, well, let's use Judge Patton and I'll sign an order.
Your Honor, do you want to go ahead and set for pretrial next month, or should we just tender an order for the mediation?
Tender an order for mediation and then we can see if we can get it in. It wouldn't hurt to go ahead and put it on the docket for May the 16th if mediation happens before then. And if it doesn't happen before then, we can schedule it. If there's a successful mediation, we can schedule it in one of the other counties.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
They're gonna have a mediator appointed to meet with you and your attorneys in the Commonwealth, see if they can work out an agreement on this, Ms. Vibert. Okay?
Okay.
They'll be over to see you.
I had spoke to him at negotiation day about a cost reduction, and he said that he would talk to y'all about it, that he would talk to them. I didn't know.
Okay, I can't understand what you're saying. Will you step away from the microphone and speak a little slower?
I had talked to Mr. James about a bond reduction the last time I was at negotiation day, and he said that he would mention it. I don't know.
Okay, well, that's what we're trying to do is get this mediation done so you won't have to wait much longer. If this mediation doesn't work out, I'll take a look at your bond or if we can't set a speedy trial date, I'll take a look at your bond, okay?
Okay, thank you.
Thank you very much. Sonny Voorhees.
Judge, I'm gonna move this back.
Okay.
Could I be heard on this quickly, Judge? I've got one of them constructive suggestions that you said you would like to hear once in a while, if you'd allow me to have one.
I appreciate that.
Yes, sir.
You know, it's Commonwealth versus Sonny Voorhees, 22 CR 0074. You Sonny Voorhees,
Yes, sir.
born in 1974, last four digits 8685. We're here on a probation revocation. What does the Commonwealth have to say?
We're ready to proceed with it. Judge, I would ask the court to allow us to continue the hearing today based upon, we've been working on this a long time. We've agreed to continue it several times. And the reason behind that is I have a strong belief, very strong belief that the two charges that I think that the court would be most concerned about in revoking Mr. Voorhees, the possession of the firearm and the trafficking, will be ultimately dismissed. We do and have provided both the Commonwealth.
Those charges pending in Barron County or what?
They are, Judge. It's a possession of a handgun and a trafficking charge, and I strongly believe, according to my conversations with the Commonwealth attorney, that those will be dismissed. The only reason they've not already been done so is due to some concerns with a co-defendant and what's going to take place in that situation. We have provided Mr. Stockton, who's not here today, I don't know if anybody else listened to him, but, and also over in the Commonwealth, a mirage of phone calls that came into Mr. Voorhees, which we believe strongly shows that the firearm was not his, he had no knowledge of it or possessed it in any way, and that he was not trafficking. I do understand that with a possession charge, that still might be enough to revoke him, but we're trying to see if we could get an
Is he on
evaluation.
a pen where he's a state prisoner rather than?
Yes, Your Honor, he is.
Well, I'm sure the Commonwealth doesn't object to a continuance if he's a state prisoner. When do you want to continue to? November, December?
No, Judge, I'd like to go past March the 20th if I could.
Next year?
I mean, I'm sorry, May the 20th, Judge.
Read something much speedier than that.
Yeah, May the 20th, Judge, if that,
No, we're not gonna be here May the 20th.
please the court.
June the 20th. We'll be here May the 16th. Or June the 20th. You think those issues will be resolved by June 20th?
I do, Judge.
Let's do June the 20th. That, is this the officer that came over to testify? I'll just recognize you to be back here on June the 20th. You raise your right hand, or you are recognized to appear here in Monroe Circuit Court under the penal sum of $50 if you don't appear, okay? Okay, thank you very much for your attendance.
Thank you,
Your
Judge.
attorney will be over to talk to you, Mr. Voorhees.
Yes, thank you, sir.
Yeah,
Good day.
Jamie Watson. Jamie Watson. Commonwealth versus Jamie Watson, 24 CI 0016. Are you Jamie Watson?
Yes, sir.
Born in 1979.
Yes, sir.
Last four digits, social security number 2051.
Yes.
You're here for pretrial conference. What does the Commonwealth have to say?
Judge, this is another one where we don't have labs back. The
What does the
incident.
Commonwealth have to say?
That, we're just need another
I mean,
negotiation.
you can do both of them if you want to. It'd go a lot faster. Just come around here, okay? We have a voice activated camera here. Tell me what you want to do.
We need another negotiation day.
Okay, and what's he charged with here? Possession?
It is, Judge. And Judge, I will say, and I'll default to the Commonwealth on this, this arrest was on.
May the 10th and then the 16th for next court appearance. Is that okay with the Commonwealth?
Yes.
Now you go ahead and say what you want to say.
Well, Judge, I was going to say, he was arrested on February 4th, so I don't know if the labs might be back by May, but that might be very presumptive.
What do y'all know about the labs? When were they sent, you know?
Yeah, we just.
What's his bond? Does he have any other charges, pretrial, know anything about it?
Judge, his bond is 50,000, 10% with an ankle monitor.
We must have some issues in what's the deal on him?
Judge,
No, I'm not asking you. He needs to be released immediately according to you, but why is the bond that much pretrial? I know you're gonna say because I said it, but why is it that it's like that?
Judge, I don't know. I wasn't on presenting to you, so I don't know what is going on with that. So,
Well, I'll let the Commonwealth discuss that with defense attorney, and they'll be over to talk to Mr. Watson about that. We'll set it then for, we don't know when the results will be back. So let's set it for review on the 16th and,
Can I say something?
wait a second. Ms. Gordon Anderson, if y'all take a look at, see why the bond is the way it is and that sort of thing, see if you got, since you don't have the results back, shouldn't hold him indefinitely on a possession charge just because you don't have the results back.
It's a trafficking charge, Your Honor.
Trafficking, okay.
It's a C trafficking with a PFO too.
That's why he's got there. Okay, it wasn't listed like
My
that.
apologies.
Okay. Okay, well, thank you very much. Your attorney will be over to talk to you. Okay, now, I really don't know if there's anyone else we haven't dealt with here.
We still have a Nick Holland here, Judge.
Let me
He was on our
find.
docket.
What's the name you're saying?
Nick Holland.
Oh, there was an order continuing.
There's an order continuing that, so you can take them off the docket, okay? And let's go, let's see if there's anybody else we have here.
We have the two people that were served.
Okay, they're in custody here, though.
Yes.
Okay, do y'all have anybody else there waiting to see us over there in Barron?
No, Your Honor.
Okay, well, y'all excused, thank you.
Thank you, Your Honor.
Yeah, let's go back here to Dockery, I guess, right? James Dockery. James Dockery. Justin Gillespie, James Dockery, and who is this lady here?
Maria Ziola.
Maria Ziola, Judge.
Yeah, I didn't see her on the docket.
You had called her earlier.
Oh, there she is.
You issued a warrant.
Yeah. Okay, you bring her around, Maria Ziola. Okay, what's the deal? There was she's just here on the motion to secure attendance of out-of-state witness.
Yes.
So there's no other reason to have her here?
No, Your Honor.
Okay, you may be excused.
Thank you, Judge.
Are you gonna withdraw the warrant? Or
Yeah, I'll withdraw the
I
warrant.
had to recall.
Thank you, Judge.
I'll recall the warrant. Yeah. James Dockery. Who you have an attorney, Mr. Dockery?
No.
This is 24 CI 0023. Do you have the resources to pay for an attorney? Okay, we'll get you an affidavit, but until then, I'm gonna appoint public advocacy to represent you.
Had the district.
yeah, yeah. Well, I was gonna say, Judge, you had a public defender in district courts.
I'll continue then the appointment. The Granger, you born in 1963. The last four digits, social security number 6386. You have a right to remain silent, continue to represent the public advocacy. Grand jury of Monroe County has charged you with failure to comply with sex offender registry first offense. Here you go.
Yeah, Ricky, something.
Sir. You can come if you make it.
Okay.
These guys are cruel.
What?
You won't come in. You won't be transferred though.
Well, wait a second. This is Mr. Dockery we're dealing with now. What's Mr. Dockery? You acknowledge the identity of Mr. Dockery, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, I'll sign a reciprocal discovery order here. Okay. It will have a, May 10th will be the negotiation day and May 16th will be the next court appearance.
Thank you, Your Honor.
Okay, thank you.
Judge, do you want to go ahead and review his bond since he was just served? It's 10,000 cash plus property on the warrant.
Leave it the same, yeah.
Okay, thanks, Judge.
Justin Gillespie. Okay, you want to help with him? Is he giving problems to come out?
He's the one giving the problem.
Okay.
Have Justin do it.
Commonwealth versus Justin Gillespie, 24 CI 0026. Are you Justin Gillespie?
Yes, sir.
Were you born in 1985?
Yes, sir.
Last four digits, social security number 5237.
Yes, sir.
You have an attorney?
Ms. Hunter was my attorney.
In
for this
district
case.
court, public advocate? Okay, I'll continue that appointment. You have a right to remain silent. The grand jury of Monroe County is returning an indictment charging you with assault in the 3rd degree, 2 counts, disorderly conduct in the 1st degree, and resisting arrest. Do you understand those charges?
Yes, sir.
You acknowledge the identity of the client, received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order here. Requires the Commonwealth to give you all the information they have to prepare for your defense. What's the bond I've set on that, Ben?
10,000 cash for twice property.
Okay, and that'll be the bond. And of course, there will be these restrictions, home, church, work, or the doctor, okay? Okay, thank you very much. May 10th, May 16th. Now, is there anyone else that we haven't dealt with? Mr. Pennington?
Judge, if I may, I've actually been in the back speaking with Mr. Newberry. He has had a change of heart, wish to accept the Commonwealth's diversion offer if that is still available.
Well, he hasn't put us in any trouble at all. Yes, it's available, Judge.
Okay, bring him back out. Now, is he the one that's causing the problems back here? Okay, come over here and tell me what happened back there.
Heard the one of it, but
You all want to come up here? It doesn't,
he said it, he didn't feel that you had the right to do what you done. And I explained to him that you could get him a lot more days once you did. And then around the way.
y'all still want to proceed with it?
No, we do not.
Okay. Okay, well, we'll just schedule it for a trial then. When are you'll be available when?
Well, Judge, I think we
We
just took the 7th would have been my availability, but that was about it,
I'm already
Judge.
back in. You want back in the case?
Judge, I didn't intend on coming back to Tompkinsville. No offense to Mr. Newberry, but I didn't plan on grandfathering any cases.
Let's see here.
But at the same time, and Judge, I don't know what the court's position is gonna be with regards to bond or
He's
remanding.
going to jail. He's going to jail. Okay. Now, you can talk to him to see if he wants to enter a felony plea. I'll give you time to come back. What's y'all's position as far as what he's gonna do here? You withdrew the pretrial diversion.
Judge, if we can dispose of it with what we proposed, which I thought was extremely lenient. But yeah,
I agree, Judge, and as a point of order, not to step on, even if we did a trial with Mr. Newberry's record, he would fit under the presumption where diversion would be the first avenue that the court or jury would consider. So,
Well, my only problem with him is I think he's been kind of jerking us around here. That's my problem. He doesn't like me, he thinks I mistreated him. And, you won't find very many people that say that I've mistreated him. I try to treat everybody with respect that comes up here. But, the problem I have is people come up, say they're going to enter a plea, they don't enter a plea. That's fine. Then they fire their lawyer when I try to set a trial date, and then they come back and they cause a big disturbance back in here and that sort of thing. I just think that you got an attitude problem. Now, I don't know you. I don't have anything against you. So we'll just let the Commonwealth meet just a second. You want to talk to him, take him out and talk to him again?
I will.
thank you. If you recall, we had a suppression hearing involving Mr. Vibert too.
Well, he's not here. Counsel's not in here, so it's no say.
Be willing to that.
I don't talk about the case right now, okay? Till they get back in here. Maybe. Do y'all have a capacity to test him? You have,
I've got a drug test downstairs.
take a drug test back. He's amped up on something. He's not acting right. I don't know whether I can take a plea for him. Okay, we'll take a recess until that's done. Do we have anybody else? Is that it?
How do you do that? Do we have anybody?
Let's go back here first and then we'll come back and put it on the record. Okay. Y'all come around this way if you want to.
We could supervise.
Come back there.
He volunteered to stay out of Monroe County, Kentucky.
That was, yes.
I mean,
You gave the right answer to the.
I couldn't say.
No.
When I got back, like, what'd you do? And I was like, I don't know.
They don't have to all have a real picture.
Yeah. There another option? Yeah. They said that, so like, they said they're all disposable. There's time to say it, as long as this case is. So, see, it's a clean case, he's not.
I'm doing this good.
Chicken.
Today, just checking, asking about that.
I was just finished. They were gonna send you minutes. And then for support. This needs to, that is it. Will be available.
He's louder out here than he is back there. By far, by far.
And then you can deposit, right, he said. We'll pass it to Cumberland County, let him enter free. No, he said he's not.
Oh, man.
Yeah, I think he is.
It's moving.
And then James said.
Got the ladies here in the back on an ex parte motion. Mr. Whitley's part to them.
Somebody's getting off.
Are we done? Amber, are we done?
Here.
Filed a motion, one.
Let's see what. Brittany calling back.
Megan said it was continued.
Okay. I think that's it.
Filed my motion. So I'm thinking. Oh, but there's an order. Well, if he pays an inquiry, he has to go. And we didn't know what to say. I have great case law. Anyway.
No, my father's brother. Custodian.
I was gonna say it. And then after it was.
You just mad because you lost some. I mean, I think that's not fair, but it's Ain't that what I do? Ain't that what I do? That's too much. I mean, I don't care. I mean. Okay.
No, front, that would be much better. But you can. Move along.
And the more you run your mouth.
I was gonna say, okay, you ran out of damn. There's one that don't, but making mistakes.
Now you can say, yeah, they shut up. I hear.
Okay. So also what's my Friday?
Feeling better than I am right now.
Sip of water, son.
Then you stir everything up, follows you right.
Yeah, actually, that's great. Just go.
You convinced him to get all these rights. If the search was invalid, just went on and on and on.
So what did Ken do? You just come in? Just starting into her plate.
Who was that?
Jason Pitcock earlier this week.
Well, it wasn't hardly that way, but he did enter a plea. There was some additional evidence that was discovered. We got word of it 5 o'clock this afternoon before the day of the trial. And respond to that evidence before the judge, that's going to destroy our theme of our defense. That's unique.
Wow.
But I guess it got.
Wow.
Well, I think the judge made most of the remark, because we had the jury sitting down, 100 people. The judge told them, that, and one reason I'm glad that we were able to do this, because whoever was picked on the jury, you do not have to disremember what you've seen. It was opening.
Oh, I know.
You had it.
Jesse, I had it for a little while, and me and Jesse had that meeting with the detectives.
Judge wants you.
And there were tons of it.
If I could avoid ever going through that again, I would.
They've been ready for an hour.
Where you been, Pat?
First order.
Why is serious? Is it short? It's on. Why is serious? And then I'll go here.
He need to be moved back there somewhere. The grand jury's coming in. We got a medical issue. Yeah, bring the grand jury. All rise to the grand jury, please. Okay, go ahead in. Sir, are you the foreperson? Everybody can be seated. Are you the foreperson of grand jury?
Yes, sir.
Mr. Bailiff, will you collect the report? Have 9 or more of you agreed on these indictments?
Yes, sir.
Okay, they appear to be in order. I will go ahead and sign the document, and we will set bonds on these things. I will remind everyone that you need to, today 18th still?
Yes.
Yeah. You need to keep confidential everything that you heard in the grand jury room for the protection of the defendants, any witnesses, and the officers involved. I understand that one of you has a need to leave, so I won't keep you around any longer. Come back here on May the 16th at 9 a.m. for your next grand jury meeting, and let's call back because of a special grand jury. Okay, y'all released. Thank you. Let's go off the record. Here you go. I'll be right back out.
Just wants to come.
No, I don't think that. If you don't mind if I listen to me, but I. A lot of drama. I didn't know what was wrong.
You got there, stop. You need one bell. If you say you want to try to think what you do. This is next time again.
You know, I'm very good. I just show her how I got it. I'm like, so we were about this. But on your record. Anne Marie from Maryland and there. So I just thought that they had started like, I'm going to go off the store because I have another. Do you swear or affirm? So you'll have to listen, like, whenever you change them over, because now that I did not do.
You wrote on it. Sorry.
Yes, I put stop.
Yeah, that made it. That's all.
Yeah, yeah, I think so that there's more people over here very much, does he? No, he doesn't. Report very much.
This is got some problem.
Lauren's policy.
We're gonna keep you on the roads.
I'm fixing to quit. Yeah, nothing but field maintenance. And one time, when we do that, listen on. You just cuss the person down. How's that?
No. Oh, well, yeah. No, but they really do need to get started. But there's no harm.
We're gonna have the capacity.
Okay. Let's come back to order here. Okay, we come back to order here. Do y'all have any report as far as the drug test is concerned?
We didn't give him the drug test. He made it the admission judge. He likes to tell you about.
Yeah.
Yeah, I would fail the drug test, Your Honor.
Okay, well, I'll hold you in contempt for violating your bond and sentence you, you come back here on May 16th and I'll consider the pretrial diversion then, okay?
And Judge, if I may, I discussed with the Commonwealth and know the 16th, they were amenable to considering trying to do this in Cumberland next week, the court be inclined.
I think, I mean, now, I mean, we can pass it till May.
What is next month? I mean, the next trial, we have May 16th here. We're next Thursday over in Cumberland County.
Correct, Judge.
I'm gonna give it a break. I'll do it next Thursday.
Thank you,
Everybody
Judge.
won't have to stay to the 16th. You know, you want a break?
Yes, sir.
Okay,
Yes, sir.
okay. Okay, we'll take the pretrial diversion plea over there and you can get him under supervision of the people in Tennessee and get him back down there, keep him out of Kentucky.
I think he lives in
Glasgow, Judge.
Yes, sure.
Oh, I thought you lived in Tennessee. I'm sorry.
No, not anymore. Your Honor, I apologize.
Well,
Just my.
listen,
I'm
man,
sorry.
you had a bad day. I hadn't had the best day. They always call it a bad conversion when two people have a bad day. You understand what I'm saying? Okay.
And with Johnny Bell there, I was supposed to go talk to him at his office. We just
Yeah.
couldn't come to nothing today. He said he's got the murder trial and he's got something else.
Yeah.
And when he's asked for me to get private, I mean, that's all I was trying to do there.
Okay, we're all right. We'll see you over there Thursday and hopefully you can walk out of there and be on your way rejoicing, okay? See you. Okay, that concludes the work of the Monroe Circuit Court.
Judge, I had one that I don't think she ever did pop up, Brittany Carnes, that was the Leslie County, which she's gonna stipulate the revocation, so.
Well, maybe Zoom her over there next Thursday too, if you can get her set up, okay? Thank you.
Did you have any? Didn't Leslie County have problem getting on last night?
They were pretty good. We just couldn't hear them. Remember Leslie County?
That was the clerk's office. That was a clerk's office issue. It wasn't.
Judge Williams, may I approach?
Sure.
Judge, my name is Danielle with the Public Defender's Office, and I'm going to be helping Candace with the
What's your
docket.
name?
Danielle Brown. I'm with the Public Defender's Office.
Yeah.
I'm gonna be helping Candace with the docket, and I wanted to introduce myself.
So where you from?
So, I'm originally from Albany.
Albany.
Yep.
Who you kin to in Albany?
Well, Dad is Roger Brown. He works for Jake Satan in the surveying office.
Yeah, I know.
Mhm.
Yeah.
Yeah. So,
Is-
yeah. Judge Lovelace's granddaughter? I thought so. Yeah,
Did you go to Clinton County High School?
I did. Yeah.
You're a lot younger than me.
I think that Megan is very young though.
Where'd you go to law school?
You can.
Undergraduate school?
At Lindsay Wilson.
Lindsay Wilson.
Yeah.
The old Methodist school when there were still Methodists alive.
Are they still affiliated? They're still affiliated.
Yeah, they're still affiliated. Who else you kin to? Clinton County.
I don't know who else you would know, Judge.
Oh, they're felons, you know.
Well, most of the people I know are not felons.
Yeah. What part of the county did you grow up in?
The highway community.
Yeah.
Yeah.
Where the Garners and all those people, like Garner used to be. Yeah, well, that's very connected to Cumberland County. You go back into, the Branham Grove Church is out that way. Yeah.
Yeah, down.
What
Cricket
church,
Road back there.
what church? is it?
I went to Five Springs.
Yeah, I know where
Yeah.
Five Springs is. Yeah, yeah.
I live right off Five Springs Road.
Oh, do you?
Yeah.
Yeah.
Okay, well, it's nice meeting you. Good luck.
You look forward to working with you,
I hope
Judge.
you're not as hateful as she is.
You know, we gotta.
Judge, I have a quick question. When you do financial reviews for like restitution, are they supposed to be here at 11 or at 1?
11.
11. See, I had a former client that's here for that and he was wondering.
They have a show cause docket.
I was never seen a show called that.
We don't have a show cause docket today, do we? We didn't ever get a copy of it.
I was never sent any show cause.
We didn't know about it.
I wasn't sent any show cause docket at all.
It was okay, you could see.
How many people we have on the show cause?
But I had to have it to prepare
So she has,
for court.
is anybody here on the show cause docket?
I need one to write on when I come.
Okay, how much you owe?
I do not know. Probably like 9 something.
Just come over here to the clerk's desk over here. Just y'all head over here today. I'm gonna pass. I'm not gonna. And what we'll do is we'll just take packets on it here. Have you made a wage assignment? What's your name?
Christopher Barker.
You supposed to make a wage, where are you working at?
Nowhere right now. I've been trying.
Well, anybody can get a job, anybody in the world can get a job. Is he on your?
I got him for parole, yeah.
I mean, how much does he owe?
Yeah, whenever I got out, they said they ran it all together. Like, it was like 1,400 altogether. So.
So the total about 1,200. Okay, you pay $500. Pay $500 by May the 16th. And then you pay $100 a month after that. Okay. You need to go out and get a job. I don't, you know, there's too many people hiring. Are you clean? Could you pass the drug test today? Tell me the truth.
Well, not for weed.
Well, weed counts too.
Yes, sir.
Okay, because you're truthful and here, I'm gonna let you slide. But you need to leave that shit alone. And you need to get you a job. You understand what I'm saying?
Yes, sir.
Okay, you come back, you be back here on the 16th. I'm gonna test you. Okay, be on your way rejoicing.
Just some paper says how much
It's supposed to start paying until 2 months. We'll take a look at it.
All right, well, I'll holler.
We need to go.
Is that your information ring? Yeah. I'm gonna tell right.
Yeah,
And when I start putting everything on it, because we were over there and she goes. Oh, I put candies on there. That one, so she can get everything.
What's your name?
Justin, huh?
Look at Justin. Huh?
Yeah.
Nice to meet you too. There you go, Brent. There you go. Yeah. I'm Robin, yeah.
Danny, make sure you know. How about that? All right. Thank you.
Yeah.
What's he supposed to be famous?
Yes.
Well, most agreements said it was gonna start paying 3 months after Judge Wesley.
How long you been there?
I've been in there for about 5 months, get out in the bank.
Okay, maybe on your way to Joyce and you started. In the May, you need to make the first payment, okay? Now, you know, he appeared today and he sits in the other, he had on May the fifth.
We had to pay. First, I think maybe 29.
Just pay up, make a notation here in court today, we have finished on May 29th, payments commenced there.
He's out and about and doing fine.
Okay, work hard on that rehab stuff.
You all gonna wind up with ambulance on the truck.
We have so more.
Lanny, come back and visit for a minute. Clayton come too if he's in a better mood.
Two that we did pick up that we'll keep yet because technically it's just James found it. We don't have those. Well, which one would you say is going to be in the biggest trouble?
Maybe.
Timothy and
Evelyn, yep. That's usually our deciding factor.
Or she was in favor of.
Next and second name.
Evelyn is probably.
Get many cases.
Had two, but one was taken care of.
So I would.
No,
I think we have definitely met before.
I think so. Might have been district court
Yeah,
or
sure
somewhere,
was.
yeah.
Yeah, but I just want to come over and introduce myself, Danielle Brown. I'm with the-
Okay.
Look forward to working with you.
Same.
How's Nick doing?
Still
He's doing well.
2 years.
Actually, this afternoon, he's got some adoption on, so.
Yeah, I see a patient over in Monroe.
Yeah, yeah, he goes just to go. Actually, I was reading, he likes them in here. Our place at 6. Obviously, so we're within a block of there, so that's
Much closer to home.
Absolutely.
Don't know how I look at it.
Look at
I just see you will miss that Sunday. I hear his trades. There's very little attention paid or organization to people, but
Well,
Parker Kitchens, I hate this entire,
so maybe,
it's all resource.
maybe there's somebody else that.
Really?
Thank
We think we do.
Just
Go out the porch down. Like,
All right.
we know she got.
I just got, we were in Myrtle Beach. And on the last day, we were leaving on Saturday.
We will definitely figure out which thing we're gonna keep.
She's got information. She's cool.
He was last day, the last day. I had drunk the whole way home. See,
Thank you, man.
it lasted. Yeah, just not getting everything right, you know. Yeah. Now, the rest of it's fine. Well, at least I don't think. Trayvon, I'd be out, but that's his Carson. I did when I was a kid, especially. Yeah,
Whatever I was in, whatever I was working was not.
When I was working.
It's just.
I didn't remember being older, come take your everything.
Or just that, yeah, it's been for a while.
See what happened.
But I think the thing that I had it on.
Like it's the fact.
I stopped driving. I was my grandpa. He was the world's worst driver in the entire world. I just started driving myself on the car. I did so we were ferry one time. Jennifer's got some Jennifer, and both of us went back to.
Oh, I know. Down the ferry.
That's the last time I think I rode them over.
Now that.
That is already.
I mean, when I started, worse, I felt like it was just so much worse. But now, I usually send back and Nick drives if we're going somewhere so that I can be with the baby, but you know, I get sick now, but I just suck it up, I guess.
There's a rain on the interstate, so we had Google Maps has taken me toward it. It was the curvy road there, but all of a sudden Trey starts crying like he's thirsty. They said, "Why are you crying? Because you're thirsty." And they say, "We know he said it."
They said they were going to Pizza Hut if we want pizza.
You're not, you can't go, you just.
Compact cases on, yeah. Hershel, let me see.
That, I understand it now. I died before that, this.
That's what I'm saying. I talked to Jennifer about that, and I thought they were going.
That, but. You'd be able to use that 3 days before trial.
Okay. Okay.
Everybody gets mad at me, but.
Yeah, because I sit down and backtrack with Jennifer to see, because we were reading that statute where it couldn't be the felony that made him a felon for the possession. And if he had received, but if he received another charge, then he could be a felon. Yeah.
I should not let it up because that's what she thought. But I could cover it.
Yeah. Okay, so I won't worry about it.
So I don't
Be a felon
worry about
instructions.
that. Try it on that.
That should be great.
Now, I have 2 officers. And then I'm telling them about. Her did it, but it's, she called that hammer 3 weeks later, just related all that, what all happened. Since the incident, her brother that was involved. And when we get around to the assault charge, it's gonna be, they were grasping for the gun, it actually. That's why I was ready to get this charge.
Probably why you should mess with the guns.
They're probably on great. Okay. Country home. Country home. I said, William, Simon, okay? Yeah, that's on great. Oh.
Whatever it's.
No. We normally don't lose them. If they talk back, I just.
Back.
Shall I go to Pizza Hut? Get cards to eat?
Oh, you want out the door, you never seen where you go. Chase trying to get me to go with him, I'll bring you something back.
Did they get Hannah Hale out of here?
They can have everything to be contacted.
Yes.
Okay. You can determine that she don't care. He's a little. Now we should keep. So he said.
That's a waste off about sense. It's interesting to see trying cases of Austria. Say I don't feel that, you know, very. It's a long ago. There's one ago. I think that's okay. Yeah, it's long. Okay. I'm sorry. I really sorry. Okay. Congratulations. Thank you very much. Okay, I actually working six. Yeah, but this is also true for Brad. I'm serving Golden Creek out. 13 years. I like walking. Sure, second. Something that works. Yes. Oh man, very same thing. He should be there. That's what. That's yeah, I know. How's that?
All rise. Monroe Circuit Court's now in session. Honorable Judge Williams presiding.
Thank you. Everyone have a seat, please. Child support docket. Carter versus Carter.
Judge, there's an order continuing that till May the 16th.
Y'all have a pen over there. One of those good pens.
That looks like it didn't want.
Yeah. Okay, you have an order to sign on it?
30 top.
They all e-filed, okay. Clary versus Clary.
Explain the Staples and please.
You swear the testimony about to give us the truth, the whole truth, nothing but the truth.
Yes.
State your name for the record, please.
Taylor Staples.
And you're familiar with the case of Commonwealth of Kentucky versus Melina Cleary?
Yes.
And Miss Cleary has a child support order of $269.10 per month. Is that correct?
Correct.
She last made a payment on November 16th of 2023. Is that correct?
Yes.
And she currently has an arrearage of $5,903.10. Is that correct?
Yes.
And as far as you're aware, she's an able-bodied person capable of providing this support. She's neither incarcerated nor a member of the armed forces. Is that correct?
Correct.
Judge Wood, the order adjudicates the arrearage and asks that she make a $1,500 sum payment before May 16th.
Okay, you all electronically file that one. Fox versus Fox next.
May the 16th?
We did Russell versus Curtis just then.
Now, that was Clary. You
The Russell versus Curtis. I
Yes,
skipped it.
also continue to May 16th.
Fox versus, is this Fox versus Fox? Is this the arrearage? Because he's been on for 13 years, you know. It's a legacy case. Gallup versus Gallup.
Continue to May 16th, please.
Turner versus Guffey.
Ms. Staples, you're still under oath. You're familiar with the case of Turner v. Guffey, which is Monroe Circuit Court 23 CI 10. Is that correct?
Yes.
Mr. Guffey was held in contempt on February 16th, 2024. Is that correct?
Yes.
He has a monthly obligation of $841.97 and he's never made a payment. Is that correct?
Correct.
And he is an able-bodied person capable of providing this support. He's neither incarcerated nor a member of the armed forces. Is that correct?
Correct.
Would ask for a bench warrant.
Okay, electronically issued. Heston versus Heston.
May the 16th, please.
Okay. Hudson versus Hudson.
May the 16th, please. Mr. Guthrie. Bench one.
I might have had a pocket full of money to pay it off. So. Jimenez versus Jimenez.
May the 16th, please.
That's been around a while too.
Yes.
Keith versus Keith.
May the 16th, please.
Electronic file. Pennington versus Pennington.
Judge, this was our motion for an arrear judgment and to calculate the interest owed on the arrears. David Cross has entered an appearance in this case. And
That'll be helpful.
No doubt. Continue it for 1 month so that he can review our interest calculations. His argument is that he was incarcerated during a portion of it, but I don't think he was, but.
That Mr. Cross was or his client?
Mr. Pennington.
Okay.
But we're just continued it to May 16th.
Okay.
He did make a lump sum payment towards the arrears to
Okay.
get this 1 month continuance. to
All right.
calculate that.
Okay. Rouse versus Rouse.
Judge, they have both hired private counsel. We've had competing motions regarding.
Okay.
Yes, Your Honor. I represent the petitioner. That would be Jackson Rouse. This originated as a divorce case. And she represents Kaylee Rouse, or now Kaylee Palmer. Ms. Palmer sought the Monroe County Child Support Office to intervene in this divorce case to collect child support. They were under an order from 2020 where my client was paying her client $400 a month just directly to her. Since the Child Support Office filed their motion to intervene, my client has no objection to them intervening to collect, but I filed a motion to modify his child support. And just based on a material change. After I filed my motion to modify, Ms. Palmer hired Ms. Coleman here, and she has filed several motions of herself.
Well, at least she didn't hire David Cross, so.
That's true. That's a positive. So. We've discussed most of our motions today. I think we're going to have to do some discovery, some exchanges to fill out these calculations because neither of us were involved in the original divorce action.
If you want to just see, I'll give you to May 16th, and if you can't reach an agreement, you can redock it and we'll have a short hearing.
I think the only issue that's not resolved is Ms. Coleman is wanting to transfer this case to Barron County, which we do have an objection to.
One of my many motions was to transfer it to Barron. The reasons being, what was
You
in
like
my,
that judge better than you do me, and I like her better than I do me too.
I don't.
it's nothing about you. I feel like there's a lot going on with the child support issue, past income and decisions that were made. We have very little to go on. I think there's a lot going on, and we also have.
Well, I'll tell you what, see if y'all can work it out and file your motions, come back here on the 16th, and if it's complicated, I don't want to fool with it, I might send it over there.
Fair enough.
We did file an order just for the cabinet to intervene.
Yeah, and I have no
No
objection.
Yeah,
problem with that.
we have no problem with that. I think that's probably best for
Okay.
everybody.
Work it out if you can.
Okay.
If you make it a little simple where I can understand it, I might rule on
Okay,
some,
but-
with a little, yeah, you're nay, flip a coin, okay?
Sounds good. Thank you.
Thank y'all very much. Brown versus Scott.
May the 16th for review, please.
Okay. Thurman versus Thurman.
May the 16th for review.
That includes your child support doc.
That does. Thank you very much.
Thank y'all very much. Okay, let's start the civil docket. Hollingsworth versus Asher. Hello.
Good to see you, John.
Okay, see if I can find that. Motion to assign jury trial, pretrial deadlines. Have y'all complied with the normal pretrial order that we have here as far as submitting instructions and the issues that will be addressed?
We haven't yet, Your Honor.
You still, is there discovery that still needs to be done?
There is. When we last appeared before Your Honor, we did inform, Mr. English was at that hearing with
I
me.
remember that.
We informed the court that we were going to try mediation. We attempted that. It was unsuccessful. And if mediation did not succeed, there was a fair amount, more than a fair amount of discovery that needs to be completed, including medical proof that needs to be taken for trial.
How close did you get on mediation? Not at all?
I've been closer, but I've been farther. It was a legitimate effort. I will say that both sides, I think, compromised significantly. Tom Carrick mediated the matter. I know he tried hard and I don't find fault. I would not find fault with either party's efforts.
How much money is involved?
There's probably, and if you look in your file, you're going to find 2 valuations for the real estate that have been provided by the executrix. Initially, she valued the real estate at like $300,000. There was a subsequent inventory that amount went up to $600,000. I will tell you, without getting the offers, I think both parties believe the real estate's probably reasonably north of 1.5. If we really had it appraised. So the values that the executrix provided aren't really very helpful. I'll tell you that. But when we got down to really discussing the crux of it, it's north of 7 figures.
Well, do you have a proposal as far as setting a briefing schedule here now?
I don't know. I'm not opposed to that.
Discovery. Well, let's do discovery. How much longer did it take you to do discovery?
I think it will take more or less the end of the year to conduct all the discovery. Mr. English's motion also wants expert disclosure deadlines, and that's reasonable, but that should not, I mean, those deadlines should come after the discovery is completed.
Well, let's set this for review on September the 12th. That way, as far as, and if you have any problems with getting the discovery that you need, we'll know it then.
And it's primarily the depositions we're talking about.
Yeah, well, that's the reason I'm giving you some time out, okay? Now, once you get the depositions done, you might have documents and you got medicals and stuff like that. Give you enough time to do that. On the 12th, let's come back here and see any motions that are necessary to satisfy everybody that discovery has been cooperative and it's been concluded appropriately. And we'll, if you hadn't reached any kind of agreement, then we'll set it for a trial date. And we can still have a trial date before the end of the year, because I'm not that scheduled on things. Yeah, you have something you'd like to?
Yes, Your Honor, please. John West on behalf of Mr. English, and I appreciate your time. Mr. English asked me to set this for a trial date, asking for a trial date, I think since February of 2023, I saw a motion in there.
Yeah.
So it's been going on for almost 1.5 years now, attempting to get a trial date. We were hoping to get a trial date and then also like within the next 3 or 4 months, and then have the expert witness disclosure during that time period. So that was our hope. My understanding is last time Mr. English appeared before you, you indicated that you would set a trial date. So
Well, I will. And what's the soonest you could finish the discovery?
Probably around September or there or soon thereafter, Your Honor.
Okay, well, let me tell you what, I'm going to combine the things is expert discovery, disclosure, and finish your deposition by September the 12th. That gives you a little certainty that you're going to have a trial sooner than later. In some places, you'd have to wait longer than he's waiting to get a civil trial date. So
places we drove from, Mr. West and I both.
yeah, well, you'll get one by the end of the year here, and it'll be firm, and it won't be sitting second. When I set a date, it's not sitting second on the docket or anything. You know, it'll go. Okay.
Thank you, Your Honor.
Cause a day like a trial like this take 3 or 4 days anyway.
It's gonna be probably 4 or 5 days.
Yeah,
I'm afraid.
I might,
Mr. English.
I have my own, rocket docket approach to that. We kind of hone it down and I interfere in people's questioning and all that kind of stuff, so. Okay, well, thank you. If you prepare an order and circulate, see if we get it, would be good, okay?
What time on the 12th you're on?
1 o'clock,
Clock?
yeah, okay.
Thank you, Judge.
And if you don't need to come back for anything at 1 o'clock, if your discovery's done, give them one of those blank, trial forms that we're doing.
Cause we don't do paper forms anymore. I can read off from the years.
Yeah. Well, I'll tell you what, we expect you to have when we sit for trial, okay? We'll forward one of those blank forms to you, okay?
Let me just send a blank one, or you want me to enter one and have it just.
Just send them a blank.
Thank you, Judge.
Okay, thank you. Yeah, absolutely. Have a safe trip home. Barbecues are open. Ramsey versus Clements. Ramsey versus Clement. Continued to May 16th. Green versus Green.
Your Honor, my client, Miss Green, contacted me shortly before court. She is ill and was not able to appear. It was our motion for, in particular, a drug screen of Mr. Green. We believe there's been an unfortunate lapse in sobriety.
Is he here?
He is not.
Well, you just want to continue this to May 16th and see what develops.
If that would be what the court is inclined to, I think that.
Yeah, I think that'd be good. And you probably need to have him probably served. Okay, have him served rather than just mail him at his last address. If he's not here on the 16th, I'll do something about it, okay?
Thank you, Your Honor.
Thank you. Hammonds versus Hammonds.
I'll just stay up here.
Just a motion proceeding in form of Pappas.
Yes, Your Honor.
I'll sign that.
Thank you, Your Honor.
Yeah. Electronically, I guess. McCarter versus Johnson.
That is me as well, Your Honor. Motion for default.
Okay, you just want to have the divorce decree entered.
Yes, Your Honor.
Separated, and then you'll do testimony and stuff about any settlement.
Yes, I will take written deposition of my client, Your Honor.
Okay, well, so you want the decree of divorce so entered already, and then any property settlement, or you want to wait and submit the.
I can
deposition?
tender you a
So
decree.
you'll do jurisdictional deposition and his property stuff at the same time?
Yes, Your Honor.
Okay, that'll be fine.
Thank you.
Keith versus Miles. Motion for temporary custody, Keith versus Miles. Do we receive any notice that would be continued?
It was noticed for last month and they filed a re-notice to this month, but.
Okay, it's called and passed
Well,
over.
Miss Anderson's not in. It's her case.
What you gotta find, Miss Anderson? I'll check that out. We'll come back to it. JLB Advisors versus Pickering. Judgment and order for sale. I don't see that. Do you see that? That's a tax case, isn't it? See if you can find it. Let me see the file. This is a tax case. These are $200. Here, just review this case. I'll take it under advisement. Want to sell land for tax bill. Reliant Loan Servicing versus Ruby A. Norris Perkins.
Good afternoon, Your Honor. William Rich on behalf of the plaintiff. This is a motion for default judgment and order of sale filed by the plaintiff. I believe there's also a motion filed by defendant Citizens Bank of Cumberland County for leave to file a cross claim against Ruby Norris Perkins. We have no objection to that motion as well.
Yeah, I believe in your pleadings, you admitted that they had priority, didn't you?
That's correct, Your Honor. The plaintiff has a second mortgage.
Yeah.
Good afternoon, Your Honor. McGavin Brown on behalf of Citizens Bank of Cumberland County, and I'm filling in for Scott Backert. In the motion, the plaintiff did concede that we have a first priority. I'll just note that in the tendered judgment or the tendered order in paragraph 5, it says that the plaintiff is adjudged to have a prior and superior lien.
Yeah, I think that was a typo.
I think it was a typo.
That is a typo, Judge. We can resubmit that order, and in fact, it may have been tendered prior to when you were e-signing. You may need a new order to e-sign anyway.
Okay, now, I guess if I allow him to file an amended complaint or cross claim rather, that there'll have to be some time given for the defendant to file an answer to that. Do you agree with that?
That's within the court's discretion. I think we can proceed, but if you'd rather allow time since they're in first position, that's fine, Judge.
Well, I'd rather go ahead and get that person served with your cross.
Yes, Your Honor.
Although they didn't deny the allegations in the initial complaint, which said that y'all had priority, I guess I could do that.
I would agree, Judge. I think we can proceed. I mean, obviously.
I'm gonna go ahead. I'm gonna go ahead and proceed with it.
Okay.
And if you paid your 200 or 300 or whatever dollars it is yet, so.
Yes,
That's
Judge.
the most important thing. Clerk gets on me if you don't pay it. Okay, well, thank y'all very much. And we'll, if you'll amend it electronically and send it to us, we'll enter it, okay?
Will do, Judge. Thank you.
Circulate it to the backer people, okay? Trenton Carroll versus Marisa Simpson. What is this? Okay, what do we got here?
This was scheduled for a review, Your Honor, to see how visitation was going. Unfortunately, there have continued to be problems.
Tell me what you think the problems are.
We believe that there's been a lapse of sobriety on Mr. Carroll's part, and he was ordered previously to comply with a drug screen and has not done so, and we would ask that he be ordered to do that today.
I did one yesterday. I'll be honest.
Okay, well, you want to suspend visitation for a while, or what do you want?
We were asking for if the drug screen was going to be positive, that should be granted sole custody of the child. He's already receiving supervised visitation with the cabinet. The only other stipulation we would ask for is that he be requested to only come to the visitations sober and acting appropriately.
Well, enter an order saying he can come sober and active. It's already supervised, so I don't want to limit it anymore. When have you ever done a long-term treatment or anything?
Yes.
The only thing on my drug screen would have been THC. A lot of rehabs only detected that one. When I did go to treatment for it, I had to throw in a couple other things that I'd done every one or twice to even get into treatment. So I've never had an issue with anything else.
Is that marijuana?
I can pop pills, on the road.
Yeah, but the problem is you need to move to another state because it's not legal here. You know, it might be sometime. It looks like sooner rather than later, but it's not now.
I'd like to also add something, Mr. Lynn.
Yeah.
Yeah, I have a lot in sobriety, but the positive things, I'm still in therapy like you want me ordered.
Yeah.
I'm still seeing my side. I actually bought a place, to have my own house, my own place now.
Yeah. Well, let's just enter an order where he acknowledged that he'd had a problem with sobriety, or he had a backslid a little bit on sobriety, and that the supervised visitation, because that supervised visitation will continue.
Okay, no determination of custody, Your Honor?
I'm not going to terminate custody at this time.
Could we request to get a hearing date for the custody?
Why?
I believe that there should just be a.
I don't see anything that rises to that level, even if everything I take that you say is correct, that it should be terminated. If everybody that had marijuana in the system had their parental rights terminated, there would be all kinds of things. She probably would rather not fool with him. I understand that. Just try to move on and take the child and not have him involved. But I wasn't the one that decided to have a child with him. And he probably was about the same he is now when he did then. So you can have a hearing, but I can tell you what the results of it, if there's no more to say than you've got now, is I'm not going to terminate.
The only other thing we think the court should be aware of is there have been some mental health concerns. I believe the court was somewhat aware of Mr. Carroll's history of mental health.
But that was taken care of by him going into these things. There don't appear to be any outbreaks of violence or threats or not taking care of the kids. He just has lapsed on his drug situation. That's the reason the visitation he has is just supervised. Not to have the children by themselves, not to take them anywhere, not to do anything, right?
Yes, Your Honor.
Okay, now I'm telling you, I will terminate if you don't conform. At some juncture, it just goes on and on and on. So you don't need to be self-medicating. If you want any medication, you need to let a doctor give it where they can monitor it, do pill counts and stuff. Okay? Thank y'all very much.
Thank you, Your Honor.
Yeah.
May I be excused? That's all I have.
Absolutely. You just take a seat in the courthouse, let them clear the courthouse before you go, okay? Okay. Okay, is that it? Hey, let's go off the record. Yeah. Do you have something?
I've signed the order.
What about this 2 o'clock here?
The warrants don't go through. Civil child support warrants don't go through e-warrants. I have signed the order of the rest.
I've got it, because I'm gonna do something.
You'll have to talk to the court. They do the e-warrants, child support payment. They go through an e-warrant.
It's whatever time. So we all put it in even tonight.
You want everything done?
Shouldn't get it.
It's the 2 o'clock hearing. I thought the 2 o'clock hearing was off.
Well, Ms. Wilt had filed a motion to continue for that. He just filed yesterday, so I didn't know what you're gonna do. So I did not pay attention on my
I
copy.
don't know. It was his motion?
No, if this is the case, Judge, they had EPO.
I remember, yeah.
And Cat got involved, and
Yeah.
then I filed a motion for the divorce case for
Yeah, I remember.
Temporary and Norb, and you wanted to hear it,
Yeah.
get something done faster than that.
Yeah. Wonder why what excuse did he give for continuing?
He's got court scheduled in.
Do you have any
Yeah.
urgency to have it heard? It was his motion or was yours or
No,
what?
I told him, I don't have any urgency, long we can have, I like to do this. There are current restrictions on her about supervision.
Okay, let's do it on,
And so it'd be on.
May 16th at 2 o'clock. And then do you want to collect something for him, give you short notice or? Okay, I'll do it if you want to. So, okay, you want to come back and see me?
Judge, we have adoptions.
Well, that day,
No, no,
what time do they start?
two.
Okay,
We're waiting on this information.
okay. That'll be good. Okay, I'll be back on the bench at 2.
I called in and I sent her a text.
Demonstrator. Yep.
I'm just gonna stick around until I hear from the cabinet and then.
Okay.
But in case we'll cut that on there or something.
Yeah. But they start to do it. Issue.
But it's not in there yet. That's dumped in my garage. She's not before last. A stunk in my garage. Not before last. Everything. We cleaned all day. I've had to wash every pillow, every blanket in the house.
So that company come over and I think you've been smoking weed.
Well, I dropped, Aubrey decided she smelled before I even got to her school and wanted to cry, and wanted to stay home. Harper wanted to go into school. About 10 minutes after dropping her off, she texted me, Mom, and people say I smell bad.
Hey.
So I had to go get her. Trey, I was like, anybody says you smell bad, I haven't called Mommy, I'll come get him. He stayed all day, he didn't care.
And stuff like that.
Yeah.
They're like this, like,
Yeah.
let me put it down, he's like, no, it's fine, Mom.
He didn't care at all. Nobody had clean shoes that didn't smell like skunk this morning. It's a full meltdown. The Rottweiler still smells like it.
Okay, Shelton Guffey is in.
Okay.
Might take a minute for it to come through, but it's in.
I have absolutely no idea what happened with this letter. It was in my mail today, and I'm looking at it, I'm like, we started doing this guy shot probation a year ago. I bet it's postmarked 2022.
Oh, what?
There was a motion for Sean Cooch. And I couldn't figure out why. I'm like, he's out of custody. Why is he writing me for chalk? And I'm like, so he wrote me 18 months ago, wanting chalk.
Tracy. I don't know who is taking it. On a Johnston. Well, I can't get my text back there. Johnston. I think he's gotten them out. Yes, they have the following things. I'll get there. Okay, he don't have right there. Okay. Now you just supposed they have it, so it looks like it. Okay, I think it's, but.
What can I aid y'all with?
She told us at the clerk's office to come up and show us, and show that the pay is fine.
Go right over there.
She's calling about that, you have bring it up, it's showing our system,
Oh.
it's just the balance of the.
Oh, so I don't have to do anything else?
Yeah. Okay,
Oh,
I'm
of
good.
course.
Not yet, just got some paperwork, but just as soon as he takes that, you're trying to get the information. That's your copy, we'll have copy when we get back down.
Awesome.
Yeah, sorry about
Thank you.
that, to come back there.
No, it's cool. It's cool. You said long divorce.
Hey, it's Tracy. I guess let me talk to Jane. Like, hey, just I know bookkeeping part of this, that receipt that they just run on that John Johnston. I put it in all under one person, so it looked like half a balance that you pulled up in the receipt system. Labor in it, half of the amount of spent. So do we adjust that, or can we do something with the balance today to make, it needs to be run under, I put it under the attorney's name. So, and that looks like they chose John Johnston's name. It's the same. They do, but what they just do is we should just put the, whoever paid it at the top, or whoever writes the check. We put their name up there, just show who paid it, because I put in the system, because I could split all the costs for final things. I had to put it all under one, so I put it all under the attorney's name. But right now. Set. Pull it up and you look at it. It's, I already put it in system, that's why I'm wondering about it. It's 23 CI 95. You know, it's got red on the guy. I think if they would just run under the attorney's name, throw it out. And we can just. Just put it under the, yeah, the Atkins, so it's the attorney. Because if they put his name on, I'm sure at the top, if not, I'll write it on there. Just each one is supposed to pay half, and all I do that do is put it under the attorney for the full filing fee. So. Okay. But I've already got all of it, like I'd have to take it out of the Atkins name. See what I'm saying? She paid hers a long time ago, had to. And he's supposed to come in and just now for me to pay it. Sorry, we've made it a mess, but. Oh. Yeah, yeah, because one of them's already unread there. It looks like out only owes $107.50. So we just need, yeah. Okay, thank you.
Thank you back there.
He ain't happy. I may or may not care.
Gosh, he's not that old. When I was putting that in, it's like $13,000 or something. It got somewhere to go.
Well, sent me a text. I told him, I said, well, I said, who put that in? He said, well, he said, I was fixing to text him. He said, somebody's supposed to be bringing this money in the next hour or something. Look, oh, well.
Funny how they can come up with it quickly.
I'd say he will, somewhere. Do what?
So nothing's come out, no.
I'm the question. Thanks so much. Bring it. So I think it would be pretty good shape. Is that still recording on like YouTube?
Yeah, just